Mayor, my lordship, I beg to mention item number 18 and 19.
18 and 19.
Yes, my lordship. On behalf of Mr. Arish Nabum. This matter may be listed after vacation, my lordship. Mhm.
What for it has been listed? This order?
My lord,
In order?
I'm for the petitioner, my lord, in this case. My lord, the state government has filed their affidavit.
They filed their affidavit.
Yes, my lord. So pleadings are complete, my lord. Matter may be listed for hearing, my lord.
Admission here.
Okay, admission. Okay. Mr.
And Sora.
Land Council for the petitioner. Also Miss Wang. Miss Wang, sorry. Land Government Advocate for the state respondent. Stuff it is submitted that the pleadings are complete. Okay. In view of the as the parties are duly represented and represented, let this matter be listed for admission after
After vacation.
3 weeks. Okay.
Immediate after vacation. My lord, fixed date may be given, my lord.
Fixed date? Why?
My lord, there is some urgency.
What urgency is there?
My lord, challenging impugn order, my lord.
Hmm?
After vacation.
Okay, my lord.
First,
After
huh?
After vacation.
after vacation.
After vacation. Okay.
Quickly.
Malat, in this matter, Malat, in this matter, pleadings are completed, Malat. This is 2000, Malat, one is Malat 2019 matter, Malat. So matter, Malat is urgent, Malat.
So what we want?
Malat, so therefore, Malat, on next date of hearing, Malat, no further adjournment. So
No,
immediately,
no, now it is, you see, they have already filed their affidavit
Malat, pleadings are completed, Malat.
and then now this will be listed for admission. When do you want? You want date to be fixed?
Yes, Malat.
When?
On Malat, 22, Malat.
20,
22, that is the number.
27, 27 is okay?
27.
27, Malat.
Okay.
Malat, may kindly, Malat, observe one more. Malat, endeavor shall be made to dispose of the Malat, the entire matter, Malat.
No need, no need. It will be listed for admission for the first time. Let us see.
Malat.
What is this matter?
Malat, no, Malat, it is not for the first time, Malat. All, Malat, every time, Malat, the matter has been listed for.
No. They are after subsequently they have recently filed their affidavit in opposition.
Malat, that's why, Malat, my commission is, Malat, pleadings are completed, Malat.
On which date the endeavor shall be made to
Right.
dispose of the matter. Okay.
Deep.
May, my lord, I would like to mention an unlisted matter, my lord. If time permits, this matter may be taken up.
What is this matter about?
My lord, here we are considering with the petitioner, my lord. The village authority has filed without has given or passed an order without its jurisdiction, my lord. So we are considering with the same. We are for a sole
You have-
respondent.
You have filed today.
No, my lord, the petitioner has filed, my lord. This matter has came up on last month, June, my lord,
Okay, then
for disposal, my lord, if time permits.
for disposal today.
Yes, my lord. We have informed the other side. It will take just 5 minutes because we are considering with the petitioner.
Are you not waiting for the vacation? Let us see.
Yes, my lord.
Last item, huh? If permissible. The other party, have you informed?
Yes, my lord.
Who is that for the other side?
Kato, sir, my lord. M. Kato.
For the other side?
Yes, my lord. He's for petitioner. We are for respondent.
Okay.
May I, Your Lordship? Your Lordship, I beg to mention item number 25, Your Lordship. On behalf of Mr. K. Loya, Your Lordship, I'm seeking an adjournment, Your Lordship.
Mr. Riram. So you are for the respondent,
No, Your Lordship, for a petitioner, Your Lordship.
petitioner.
On behalf of Mr. K. Loya.
Lolan. Have you informed the other side?
Yes, Your Lordship.
Riram Learning Council. Hearing on behalf of Mr. K. Lolan, Learning Council for the petitioner. The appellant, Learning Council for appellant, with the consent of the Learning Council for the other side, seek adjournment of the matter to be listed after 3 weeks.
Yes, Your Lordship.
Okay, the prayer is allowed. List this matter after 3 weeks. Okay.
Oblige, Your Lordship.
May I please, Your Lordship? I beg to mention unlisted item. Lordship, the matter may be taken up as a last matter.
What is this matter?
There is an
about?
urgency
What
on-
what is the urgency?
on
What is this matter about?
the complaint case.
Hmm?
In complaint case, I'm praying for the setting aside of the impugned order whereby the learned judicial magistrate has directed the accused person, the petitioner, to pay the interim amount. If the interim amount is not paid, then his right to cross-examine the witness will be forfeited.
In the
And the
complaint
matter is fixed on coming 16/7/2026.
there is no stay.
No stay.
Last item already there.
Hmm.
There cannot be two last.
Tell us if time permit, then kindly the matter may be taken up because this matter is urgency. Because if the order is not stayed, then the right of the accused person to
Okay,
cross-examine
let us see, huh?
obliged.
Yeah, Your Lordship, I beg to mention item 15. I'm appearing on behalf of Deep Mangi. I've taken concern from other parties.
Okay. Mr. Tajo, Land Council, appearing on behalf of Mr. D. Pang, Land Senior Counsel for the petition. With the consent of Land Council for the respondent, prays for adjournment of the matter. To be
After,
listed after 3 weeks.
yes,
After the prayer is allowed, list this matter after 3 weeks.
Your Lordship, also one more item, item number 26.
26.
Hmm.
Here also same. Similar order. Here also you are appearing on behalf of Mr. D. Pang.
Yes, Your Lordship.
Okay. Similar order. Here, the state is there. No objection. Okay. The Land Council appearing on, Ms. Cheney, Land additional PP for the state has no objection. Prayer allowed. This is matter after 3 weeks. Okay.
Madam Lord.
Item number 1.
Done.
May I please, my lord?
Yes.
My lord will find the impugned order at page number 29. In this case, we are challenging the order passed by the deputy commissioner, wherein the deputy commissioner has endorsed a matter to be adjudicated by the East Coming Gaon Buraburi Welfare Association.
Page 29.
29 is the order, my lord.
This is,
By way of
Deputy
this order,
Commissioner
my lord,
endorsed to,
the East Coming Gaon Buraburi Association, my lord.
okay.
And the impugned order, which has been subsequently passed by the Gaon Buraburi Association, will find at page number 30, my lord.
CRP. Okay.
And then the
Where is the impugned order?
page number 30, my lord. My lord, may kindly
Where is the complaint?
complaint, my lord, will find at page number 28, my lord.
28.
28.
Complaint was lodged by whom?
Complaint by the petitioner, my lord,
By the
by
petitioner.
the petitioner. Since there were some issues.
But
pertaining-
you lodged complaint before the deputy commissioner.
Yes,
What you want the deputy
My lord, the
commissioner to
deputy
do?
commissioner ought to have referred the matter to the concerned village authority, my lord, not to the Gaon Buraburi Welfare Association, my lord. And
Okay.
this issue is no more res integra since my lord has settled this issue, my lord. Is the village authority,
Yes, but then association.
my lord, may kindly peruse the heading of page number 30, my lord.
Okay, this was endorsed to welfare association.
Yes, my lord. So that is the only concern, my lord.
Mhm.
And if my lord allows me, I'll just place the authority, my lord permits, which has
Hmm.
been passed by this honorable court itself, my lord.
Okay. Okay. Will issue notice
My lord.
or Mr. J.T. Key, Land Council for the petitioner. Which paragraph, yeah?
Para, my lord, will find para 9, my lord. And also, my lord, may kindly have para 6 also.
Mm.
My lord's observation is at para 10, my lord.
Okay. This the present civil division petition filed under Article 227 of the Constitution of India is directed against the order dated 16/4/2026 passed by the Deputy Commissioner. It's the Deputy Commissioner,
My lord,
East Coming
is
District.
coming, district,
East Coming
is coming.
District, referring the dispute referring the complaint of the petitioner to all East Coming Gamburi Welfare Association and on the consequential judgment stroke order dated 18/5/2026 passed by the said association. Stop, huh? It is submitted that that under the provision of the Arunachal Pradesh Civil Code Act. It's under the Civil Code Act.
My lord,
Okay. 2023. The civil suit, the customary court has, of the jurisdiction has the power to entertain complaint and decide, adjudicate the matter, however, and not the Gambura and Gamburi Association. Start. And in view of the above, the Deputy Commissioner East Coming District ought to have referred the matter for a matter before the Gambura of, the customary court of the village having jurisdiction. Stop, huh? Para. What, is there any prayer also? Interim prayer
yes,
also?
my lord, I have.
What is,
Staying the,
what order was passed by the Gambura and Gamburi Association?
even the order itself is, subject to certain clarification also, my lord. My lord, may kindly have page number 33. 33.
What order was passed?
It has stated that, my lord, status quo shall be maintained. And in the meantime, my lord, the property has been given in possession of some other committee, my lord. Even that is without jurisdiction.
Hmm. Okay,
Tungma Development Committee Society.
issue notice, huh? Returnable by 4 weeks. Staff, the petitioner shall take steps for notice upon.
Private respondent number 2.
Service of notice upon the private respondent. Who is one then?
One is the Deputy Commissioner, my lord.
Deputy Commissioner.
My lord.
So Deputy Commissioner is required to be impleted.
My lord, since his order for
State probably. So who represent Deputy Commissioner? Are you?
Yes, ma'am.
Okay. So we can issue notice. You accept notice?
Yes, ma'am.
Okay. Then, then Mr. Then, okay. His name, huh? Accept, notice on behalf of the respondent number 1. The petitioner shall take service of notice upon the respondent number 2 by a speed post as well as by usual process within a week from today. Stop. Para, list is matter after 4 weeks. Stop. Para. In the meantime, the operation of the impugn, this stay will be with, only with
Just been an
regard
order
the
dated.
order only,
My lord, 18/5/2026.
expiration of the order dated
18/5/2026.
18/5/2000, 18 or 15?
My lord, 18, man.
Hmm?
18/5.
Okay, 18/5 to 2026. Shall remain state till the next returnable date. What the dispute is about?
About the land, my lord,
Land.
land. Actually, the respondent is my cousin brother. And initially I was under the possession of land.
What, anything going on there in the,
I mean, like
Is
he
it
was
okay?
carrying out a quarry
Hmm.
in my land, my lord. And he was trying to obtain a LPC without my knowledge.
now if, so by this stay order, the stay order passed by, the impugn order will be, that means automatically
Be a statement.
stay.
A statement.
So that means who will be operating the land in question?
But that will be under my possession only.
No, you said that he is.
He was initially carrying out a quarry
uh,
in that land.
query.
Yes, my lord.
Now he will come then.
But he will come in place. I mean, like as before, but I would be filing a civil suit for that matter.
However, then we'll ask for direct maintaining status quo.
My
But
lord,
however,
that would be so.
both the party shall maintain, are directed to maintain a status quo or with regards to the nature and possession,
My lord,
nature and possession of the land in question.
Right.
And shall not alter or create third party interest. Okay, till further order.
Right.
Okay.
deeply grateful, my lord.
Item number 2.
Yes.
May I please, Lordship?
Hmm.
Lordship, this civil review petition is filed by the petitioner challenging the impugned judgment and order dated 15 February 2025 passed by the Inter-Blaze Customary Court, Naharlagan Circle at Lekki Village, as well as executions notice dated 06/2026, issued by the Extra Assistant Commissioner Naharlagan on the ground that in terms of Section 5, Clause 6 of the Assam Frontier Administrations of Justice Regulations Act, as well as under Section 2, Subclause D of the Arunachal Pradesh Civil Code Act,
What it says,
uh,
that provision?
Section 5, Clause 1, it's talk about the appointment of,
Yes. Appointment.
yes,
Yeah.
and subclause, Section D, Section 2, Subclause D of Arunachal Pradesh Civil Act, it's talk about the village authorities.
Hmm.
The Inter-Village Customary Court has no authority to entertain the civil disputes and lacks of
Oh,
jurisdictions.
it was settled by inter-village.
Yes, Your Lordship.
Okay. Who lodged complaint?
Private respondent number 3.
Private respondent.
Yes, Lordship.
Before, which
They,
authority?
before the, first they have lodged, they have filed complaint before the Extra Assistant Commissioner in the year of 2000,
Deputy Commissioner.
subsequent complaint lodged before the Deputy Commissioner. And Deputy Commissioner has endorsed to the ESC, and ESC has endorsed to the village authority, but the impugned order was passed
No,
by the
no,
Inter-Village
before
Customary.
EAC is for execution.
And now they have filed
Complaint was before the
execution
Deputy
petition.
Commissioner. Complaint was before the, I think, before the Deputy Commissioner. Okay.
Lordship, the petitioner is is a widow of the younger brother of private respondent.
But the land was given by your husband.
No, Lordship. The land,
He paid,
no, Lordship.
your brother-in-law paid the money.
But the money was paid on the ground of humanitarian because
How much?
30 lakhs, Lordship.
30 lakhs humanitarian.
Lordship,
Little bit difficult.
Lordship, the petitioner's late husband took a loan for his
Yes.
medical conditions. He
Yes.
was expired in the year of 2023.
Yes, but then the house was seized by somebody.
The house was tried to,
Then he repaid
yes,
took
Your
the,
Lordship, but
house, then that means it is equivalent to purchase.
yes, Lordship, but
Because
but-
given the amount to him, it was taken by the other person. This brother paid the money
Lordship, the petitioner
that
is,
belongs to him, then if he has paid.
there was no any agreement was made between the petitioner late
But
husband.
admittedly, it was paid.
Yes, it was paid.
You have to tell her
Uh,
that unless you repaid this amount.
Petitioner is,
It'll be difficult.
petitioner is willing to pay,
Okay,
but the village authorities, they are not considering her submission.
okay. Petitioner is ready to pay.
Ready to pay, but since
Okay.
she is a mother of 3 minor children, and she has no concrete income source, so she was plead before the Inter-Village Customary Court that some time may allow to pay
Okay,
the
time was not granted. Okay, yes, we can issue notice.
Yes, my lord.
Okay, heard Miss Miss
Miss T. Anmol.
P. Anmol. P. Anmol, learning counsel for the petitioner. No. Okay. Also heard Mr.
They come to
Kamduk, learning counsel appearing on behalf of the respondent. number.
Lordship, may pass stay order for now because the executions,
Mr. Kamduk, you are for the respondent number 2 as well.
yes, my lord.
Okay, your respondent number 1 and 2. Staff, huh? This, the present petition under the present petition has been filed under Article 227 of the Constitution of India, read with Section 115 of the Civil Procedure Code 1908, challenging the order dated 15/2/2025 passed by the village authority,
Inter-village.
inter-village customary court, Nahalagan Circle at Lekhi Village. And also the also the execution order dated 26/6/2026 issued by the Extra Assistant Commissioner Nahalagan. What execution order was passed?
To execute the
Where is that order?
Lordship, turn to page 23, annexure 2.
Read the relevant portion. Where is the order to execute?
Page number 23, Lordship.
Read the relevant portion. Only the matter will be
The
taken up.
printer.
Hmm?
Oh. The execution shoot number 02/2026 between Siri Tok Kale and Degree Holder and Srimati Tok Ania, judgment debtor was taken up for hearing today and served
There is
the
no order.
copies of the execution
Only it says
petitions.
that matter will be taken up on 10/7.
Yes, Lordship.
No order. It is submitted that the Inter-village customary court, Nahalagan. No. Under the AFI and the Arunachal Pradesh Civil Court Act, the Inter-village customary court doesn't have lacks the power, lacks jurisdiction to decide, adjudicate the complaint on land dispute. It was lodged before the deputy commissioner.
Yes, Lordship.
Extra assistant. And an issue process, an issue process. Okay, they have already decided. Now the notice is issued by the execution court. Okay, decide the land dispute matter. However, in the under the Act, the Inter-Village Customary Court is an appellate authority and cannot entertain the complaint and decide the matter.
My lord, may I kindly interrupt, my lord?
Hmm.
My lord, may I kindly see the
This was also ex parte.
nil declaration, my lord.
Mhm.
It was passed in the year 2025 in the month of February, my lord.
Okay.
Even CRP does not lie.
Hmm?
This application ought to have, my lord, accompanied with this application for delay of condonation. My lord, may I kindly see annexure
No, this is
one
revision.
page 50.
This is not appeal.
This is not appeal. CRP, my lord, for CRP also, my lord, the prescribed time limitation, my lord.
Revision.
Yes, ma'am.
Lordship, in that regard, I would to like to submit that.
Because, my lord, this execution petition, my lord, this is the offshoot, my lord, consequential
sorry.
order. which is based
Execution
on
was passed.
The nil order passed on 15 to 2025, my lord. This in fact, CRPC is not maintainable.
Hmm?
In that regard, Lordship, I would like to submit that
More than 1 year
on
elapsed, my lord.
on 26/06/2026, I had appeared before the executions date that I have also submitted that the impugned order copy was not served to the petitioner.
When it was served to you.
On 26/06/2026, on the date of hearing.
Where have you stated? your
I have
petition?
stated in page number 23, annexure number 2.
Yeah, they says that you have received the copy of the judgment.
No, Lordship, I haven't received the copy of the judgment. For that regard, I availed the impugned judgment order through CTC.
Imperative to commence. CTC of the judgment of the past by. Oh, what is the limitation otherwise?
30 days, my lord.
For civil revision?
Yes, my lord.
Where do we
I-
find?
My lord, can this matter will take up after some time, my lord, so that I can, my lord, so the limitation, my lord.
Lordship, I would like to make submission that the Inter-Village Customary Court is the appeal authority, and the trial has to be conducted in the village level. But they have passed the village authority, village level, and directly they have passed this impugned order from the Inter-Village Customary Court.
No, in any case, this inter-village customary court doesn't have power.
That is true, my lord, that is admitted, but,
Hmm.
my lord, but then, my lord, that has to be challenged, my lord, within the limitation period, my lord. If it is to be challenged, my lord, again, my lord, they have to file separate application for condemnation of delay, my lord. until the delay is condoned, my lord. They cannot assail this execution petition, my lord.
Where have you stated regarding delay in filing? In your petition?
Lordship, I haven't mentioned about it.
I thought this is 26. You see, the order was passed on 25. For appeal, there is a one is to file, of course, within the period, but then this is a civil revision.
May I please? I'm just assisting, my lord.
Mm.
After passing of this impugned orders, the Blaze Authority, Inter-Blaze Authority has not provided the judgment copy. And
No, where
therefore,
have you stated
yes,
in your
No,
petition?
it is not specifically, but
Oh,
it is
then-
clearly, my lord, reflected in Annexure 2.
No.
Annexure 2 at that day, I have read.
You have to state.
Let us come to the Annexure 3,
But
my lord.
let us see, what is the limitation period for revision?
In civil revision
Wait.
petition, there is no
Okay,
specific limitation periods.
Let him place.
This is not a,
Let him place, huh? After some time. Let him place if there is provision. Okay. After some time.
Item number 3.
May I please?
Yes.
Well, here on this civil revision petition, I have been questioning the authority of one village authority to taking up the case of another village authority. The village authority of another village is taking up the case of my village, in my case. I'm questioning that power of village authority and passing of an impugned restraint order to restrain me to cultivate my WRC field in this cultivate season, my lord. My lord, there is an, my lord, may kindly come to page 22.
Restraint order
Yes, restraint order is in page 20.
passed by
Passed by the village authority of Seren village.
Seren.
Yes, I am from New Seren village. There's two villages, Seren and New Seren village.
Okay.
The state, as per section 5 of AFR Act, they have separately appointed different gamburas.
Seren has different gamburas.
And
head
New Seren
gamburas,
has different
New
gambura.
Seren different.
Now,
So-
matter has been taken up by the Seren village. authority.
Seren doesn't have a jurisdiction
No,
over the New Seren.
yes,
So you are from New Seren.
I'm from New Seren and
Where the land is located, in which jurisdiction?
Len is
Land
located
in question?
in New Seren village.
New Seren.
Yes,
You are in New Seren.
yes, I'm in New Seren.
Okay.
And my lord, Makam, page 34 is the LPC of the land, part of the land.
What is this?
This is the LPC of the suit land. The last
Okay.
line handed
New
over.
Seren.
This New Seren Ego River bed. It's in Assam, it's called Cement River. It's situated in Ego River bed. Madam. So, my lord, this Seren village authority has taken up this matter and passed this impugned order. May I read out the order?
What?
Whereas a land dispute between yourself and Kegodoi is
Which
under,
one?
page 22.
Okay.
Whereas a land dispute case between yourself and Sri Satyan Sat.
What is this letter?
This is a restraint order, man.
Restraint order.
Yes, injunction restraint order.
So you were issued someone.
No, I have not issued someone.
On 24, they call for spot verification. I attended. And as per this order, it was declared on that day, but no Parwana, they usually issue once someone called Parwana. That was not issue. And they said that in that meeting, in the spot verification, they have declared that meeting will be held on 24. So this has been passed in my absence. So
So whose possession the
L-
land in question is at the moment?
your land is in my possession.
Mhm.
Malum can come to page 28. Page 28 and 29. This is the photographs of suit land.
Okay,
So in this area, the month of June and July is the cultivative season. Without giving any opportunity, they have passed this impugn order. And further, as per section 41 of AFR Act,
Hmm.
in absence, when the party are deliberately absent, they have power to impose cost, not any such orders. 41. If any party is deliberately
okay.
absent,
Will issue notice?
well, this
Hard.
order may be still.
Okay, heard Mr.
Ketab.
K. Davi, Land Council for the petitioner. Please, para. The present application filed under section, under Article 227 of the Constitution of India, read with section 151 of Civil Procedure Code 1908 is directed against the restraint order, which order dated
24 June 25.
24
June 26.
6, 2026. Passed by the Seren village, passed by,
Seren Village Authority.
not Seren, the GB's, GB.
Yeah.
GB, Office of the Head Gambura. GB Seren Village, Lower Siang District. It's Nari,
Yes, that.
Nari. Whereby the petitioner has been restrained. It's a maintenance of a status quo.
No.
Where is the restraint order?
You undertake any cultivation, construction, felling of trees.
Restraint from
Yes.
undertaking any cultivation, construction, fencing, tree felling, sale, transfer, encroachment, or any other activities on the dispute, on the land in question. Stop. Para. It is submitted that the dispute relate to
Land.
the land situated within the territorial jurisdiction of New Seren.
Yes, New Seren.
New Seren village. This is New Seren, yours is New Seren village. However, by the impugn order, the GB of the Seren village.
Yeah.
Seren village has restrained the petitioner from undertaking any activities in the suit, in the lane in question. Stop, therefore. And, oh. No, leave that, huh? Last part. Territorial jurisdiction under, situated within the territorial jurisdiction of the New Seren village. Therefore, the the village authority of Seren village lacks jurisdiction over the New Seren village. Dispute in the within the New Seren village staff. Further, it is submitted that the proceeding further before passing the impugn restraint order, no opportunity was given to the petitioner. Stop. Para. Issue notice. Returnable by 4 weeks. Stop. The petitioner shall take steps for service of notice upon the respondents by speed post as well as by usual process within a week from today. Stop. Para. In the meantime, the operation of the restraint order dated 24/6/2026 shall remain stayed till the next returnable date.
My lord, may the above proceeding also. Because
So,
this
further,
matter-
the proceeding pursuant to the, this is summon.
No, no, my lord, this proceeding will, they may proceed with the.
Whether this is summon. Is this summon, Borough Village Authority
in
to
here-
proceed with the matter on the basis of available fact and record? Is
They will
Okay.
proceed, man.
The further proceeding pursuant to the summon issued to the petitioner shall also remain suspended till the next date of next returnable date.
But no, someone has been issued to me till then.
What is this then?
Ma-
It's non-attendance in lane dispute. You did not attend.
This only interim order.
Hmm?
This only interim, order. They have not mentioned the date.
You are directed to appear on the next date. This is summon only,
But.
which shall
the-
become
And
and cooperate with the proceedings. This is summon only. You are asked to appear. So that proceeding
probably.
pursuant to the this order. Okay. Shall also remain suspended till the next date of listing. Then you maintain status quo then?
Yeah.
Okay. Para. However,
No, my lord, it's all.
status quo as of now.
Yeah.
Status quo is that it is in under your possession.
Yeah.
Okay. It's okay.
Yeah.
It's not a prayer.
Yeah.
Okay.
Item number 4.
May I please, Mr.
What is this?
My lord, similarly situated cases, my lord. In here, my lord, the Gawabura of Diking village issue summon against me to conduct kabang. I am the resident of Balak village.
Okay, the different village Gambura
yes,
has issued someone against you.
Yes. The disputed land is under the jurisdiction of Balak village.
Same. Same order, same. It is-
Similar situated matter, man.
Mhm.
My impugn summon is at page number 39. Translated copy, page 14.
Mhm. Your property where it is located, you said?
Property located under the jurisdiction of Balak village.
Uh-uh.
Under
Balak.
the jurisdiction of Balak village. ma'am.
Balak.
Yes, ma'am.
So the king has issued.
Yes, ma'am. Digging is different village. ma'am.
Hmm. So when, this is summon,
Yes, ma'am. There is
page
some-
40,
Page 40 is,
when you are directed to appear. Similar order then, heard Mr.
M. Doji. ma'am.
will issue notice, okay.
Yes, ma'am.
M. Doji, land counsel for the petitioner, stop, para. The present petition under Article 227 of the Constitution of India is directed against the summon dated 6/6/2026 issued by the, where is GB, head GB?
No, ma'am.
Who?
Gaon Bura
GB.
village. ma'am.
GB of the King village, the King, DIKING, huh? The King East Siang district. Whereby, when you are directed to appear,
11/07/2026.
whereby the petitioner has been summoned to appear on 11/7/2026 in connection with the complaint lodged by whom? In
Respondent,
connection
ma'am.
with the land dispute.
Yes, land dispute, madam.
Case, land dispute. Case arising out of complaint lodged by the respondent. Respondent
Yes,
number?
respondent, ma'am. Sole respondent, ma'am.
Okay, respondent, stop, para. It is submitted that the dispute related to lane. This is a lane,
Yes, land. ma'am.
okay. Related to the lane situated at,
Sile area, ma'am.
within the jurisdiction of Sile area
Balak village. ma'am.
of Balak village, Sile area of Balak village. Stop. Therefore, the king doesn't have.
No, ma'am.
Therefore, the village authority of the king village has no jurisdiction to decide a matter. Falls under the jurisdiction of the Balak, Sile area.
Malad, laying is the
Lay-
area
huh?
name, madam.
Huh?
Laying is the area name, ma'am.
Laying area of Balak village.
Yes, ma'am.
Okay, stop. Huh? Earlier also laying is, make it laying. Stop. Huh? Issue notice. Returnable by 4 weeks.
Madam,
The-
I had an interim prayer.
The petitioner shall take step for service of notice upon the respondent by speed post as well as by usual process within a week from today. Stop. Para, huh? In the meantime, the operation, sorry, in the meantime, the further proceeding pursuant to the summon dated 6/6/2026
Yes, madam.
issued by the GB of Dicking village shall remain suspended till the next returnable date. Okay,
Deeply aware.
is this matter after 4 weeks.
Item number 5,
Earlier one also after 4 weeks. Huh?
Matter will pass over for time being. Conduct,
5,
yes, madam. Conducting council is, matter is lagging on.
okay, after some time.
item number 6,
May I please,
Yes.
my lord? My lord, I have filed one additional affidavit. Additional affidavit.
In item 6,
Yes.
what
To
additional
insert
affidavit?
the GR number here.
Hmm?
To insert the GR number. In main petition, GR number was not mentioned. So that is why I have filed additional affidavit to insert the GR number, only GR number.
Okay, who is for the state? El Hage.
Yes. Lordship, hearing was already conducted, she was
Hmm?
no objection. The issue was that
He
only,
has no objection.
no objection.
Okay,
Only
You
issue
know that.
remain, issue remain was that the GR number was not inserted.
Learned counsel for a petitioner says, submits that you have no objection.
Lordship, this matter, Lordship, is taking 2-3 days, Lordship. They have already,
They did not fulfill. They did not complete, and then there was some defect in the petition. They did not insert the number also. But then otherwise you have no objection.
no, Lordship, because
Okay. So
otherwise it's settled, Lordship.
ultimately, order need to be passed.
Lordship.
Okay, heard, Mr.
El Kagum,
Learned counsel for the petitioner. Likha Kagong, learned counsel for the petitioner. Also heard Ms. El Hage, learned additional PP for the state of Arunachal Pradesh. Stop para. Is this a joint petition?
yes, joint petition.
This, the present application under section 528. Of Bharatiya Nagrik Suraksha Sanita 2023 has been jointly filed by, who is the informant? Which one?
Informant,
Hmm?
this number 3, my lord.
Petitioner number 3 is informant.
Yes,
Are you sure?
yes, Pranab Gohain.
Okay, and then one is,
1 and 2 is the accused person.
oh, 2 accused person,
Yes, 2 accused person.
informant and accused, praying for setting aside and quashing of the, where have you mentioned the GR case number? Where do
Additional,
we find?
additional affidavit.
Hmm?
In additional affidavit.
Okay. GR case number, question of the GR case number 863/2021, arising out of FIR 61. FIR means which PS case?
New Jersey
Arising out of New Jersey PS case number 61/2021 under section 447, 295, 504, 325, 427, 34 IPC. Charge sheet was filed.
Yes, just to five. Now in a stage of
Okay, stop.
PC.
The petitioner number 1 and 2. The petition number 1 and 2 are the accused, and the petitioner number 3 is the informant in the aforesaid GR case number arising out of Nirjuli PS case number 61/2021. Stop para. The case leading to the filing of this petition is that on 17/9/2021, the petitioner number 3 lodged a written FIR before the officer in charge, Nirjuli Police Station, against the petitioner number 2 and 3, alleging therein that the accused, both the accused has mercilessly beaten him inside the pandal. No, how many? No. Learning Council, there is more accused, no more victim. 1, 2, 3, 4, 5. Where are they? I think
Regarding that, I have filed out another additional affidavit.
you could have informed. Then here. who- then the first paragraph, the petitioner number 1 and 2 are accused, and petitioner number 3, 4, 5, 3, 4, 5, 6,
7,
7,
yes.
3, 4, 5, 6. How many victim? 1, 2, 3, 4. The last one would, who is the seventh one?
Kako Gogoi.
Hmm?
Kako Gogoi.
How many victims are there? Okay, 7, huh?
Yes.
No, 7. The informant, no, petitioner number 3 is the informant.
Three
And
is the informant and
4,
4 to 7
5,
is
6, and 7 are the victim.
victim, yes.
Okay. Then continue the last one. Two accused person has mercilessly beaten the victims, beaten the petitioner number 3, 4, 5, 6, and 7 inside the pandal, as well as in in the private bedroom, while the pandal was already closed. Further, the accused petitioner number 1 and 2 has completely damaged his car and pelted stone damaged car and the scooty, and pelted stone on it. Stop. Stop. Based on the aforesaid written FIR, the aforementioned Nirjuli PS case number 61 was registered and investigated into. Stop. Upon completion of investigation, the police has submitted charge sheet against the accused petitioner number 1 and 2 for commission for where is the of the offense punishable under section 447, 295, 504, 323, 427, and 34 IPC. Stop. Whether the magistrate has passed any order?
No order.
What is the stage of the trial?
It is CC.
Already framed?
No, not frame. It is yet to be
The
framed.
magistrate has taken cognizance of the case. However, the case is still pending at the stage of the consideration of charge before the court of, which court?
JMFC UPia.
Judicial Magistrate First Class?
Yes, first class.
Where?
UPia.
UPia.
Yes.
Stop, Para. The Learning Council for the petitioner submits that during the pendency of the trial, the parties have amicably settled the matter and executed deed of mutual settlement where deed of settlement dated
On 20 June 2026.
2026, whereby all the victim has categorically stated that they have pardoned the accused for their mistake with the view to maintain peace and harmony between the parties. Stop. And that the mutual settlement further declares that the victim and the victim and the informant has no further grievances against the accused, and they do not want to pursue with the matter any further. Stop. In view of the above, the learning counsel for the petitioner submits that there is no scope of any conviction in the case, and under the circumstances, the further proceeding of the case would only cause harassment to both the parties and would amount to an abuse of the process of law. Stop. Para. Therefore, continue after stop. Therefore, the learning counsel for the petitioner prays for setting aside and quashing off the aforesaid GR case number so and so arising out of near Julie PS case number so and so in the interest of justice. Stop. Para. Miss L. Hage, learned additional PP for the state, clearly submits that in view of the case having been mutually settled between the parties, and considering that the victim and the informant do not have any further grievance, and they do not want to pursue with the matter any further, she has no objection if the prayer of the petitioner is allowed for setting aside and quashing of the proceedings. Stop. Para. I have heard both the learned counsel for the parties. My part I'll dictate. Okay? Dispose. Huh?
Applies.
Item number 7.
Lordship,
Yes.
one criminal petition filed under section 528 of GBNS 2022 for the quashing of the FIR dated 07/2/2023, registered as Mitibia Police case number 04/2023, and the charge sheet number 03/2023 dated 19/4/2023 under section 341 and 325 IPC, and the corresponding to GR case number 102/2023 under section 324 IPC, pending in the trial court judicial magistrate.
Oh, what is the punishment for 325? Charge sheeted under charge sheeted under 325.
No, 324.
324. Okay.
Yes, so 325 was altered to 324. Yes, Lord. FIR was registered under section 341 IPC and 325.
And charge sheet filed under
Charge sheet filed under 324.
where? see page 23. Where is the last order? Order passed by the magistrate. Where is that order? Last order passed by the magistrate or any order? Okay, 325. Pray that section 325 may be altered to 324. Okay, just a minute, huh? Is altered to, okay, 324. Okay, because charge sheet filed under 325 only. So this has been altered by the order of the magistrate. Charge framed? Okay, charge also framed.
Yes.
When this was? What is the stage of the trial? How many witnesses have been examined by now? Hmm? Yeah, yes, Miss, want the record to be called for or what?
Lordship,
Or what?
because the last order has not been annexed, Lordship, then record may be called for, stay may be granted, Lordship. Because he they already settled their
Mhm.
grievances, Lordship.
Okay. Otherwise, 324. Oh, okay. We'll call for the record then. Hard, Mr.
Yeah, though.
Lanet, huh? Mr.
Yeah, though. Kirmara, though.
Okay, Kiado. Lanet counsel for the petitioner. Also hard, Miss L. Hage. Lanet additional PP for the state. Stop, para. This is an application filed under section 528 of the Bharatiya Nagarik Suraksha Sanhita 2023, praying for quashing of the GR case number 102/2023, arising out of which PS case? Niti Bihar PS case number 04/2023 under section 341, 325 IPC. Stop, huh? Para. Issue notice. Call for the scanned copy of the trial court record. Stop. Issue notice, since Ms. L. Hage appeared and accepted notice on behalf of the state respondent, no formal notice is required to be issued. Stop. Call for the scanned copy of the trial court record. Stop, List this matter. When?
The court vacation,
Lordship.
23.
20.
23 July.
Lordship.
Stop, Para. In the meantime, the proceeding of GR case, further proceeding of GR case number 102/2023 under section 324 IPC, pending before the Chief Judicial Magistrate India cell, remains suspended till the next date of listing. Okay,
Lordship,
list.
Lordship, trial may be stayed.
Double stay. Okay.
Okay.
Item number 8.
Yes.
Your Lordship, today's petitions, I'm challenging the FIR and the corroborating charge sheet that has been filed against me. The FIR is dated 18/9/2025, and the allegation against me is that I have withdrawn a sum of rupees 10 lakhs.
Just a minute. Where is the fire? Page 20.
That is the initial FIR, yes. That is the initial FIR. The FIR, this FIR was initially lodged at Pasigat. This is a zero FIR in Pasigat.
Which is the zero FIR?
This, the page 20.
Page 20.
The content
Okay.
is same. It's a zero FIR. Subsequently, it was forwarded to the concerned jurisdiction police authority. which was renamed as
Unauthorized.
Saleh Oyan case number 17/2025.
This was FIR was lodged before the police station Pasigat.
Yes, initially.
And the incident took place where?
That is in Saleh Oyang. This is also within,
Sile Oyang.
yes,
Sile Oyang have different police station.
yes.
Okay,
The allegation against me, Your Lordship, is that I have withdrawn a sum of rupees 10 lakhs.
just a minute, huh? This is to inform you. Happen to obtain the passport of my ruler. 10 lakhs.
Yes.
I have not given permission to. So the accused is a stranger to the informant.
That is her allegation.
Permission to no, account. Did not issue check.
As per the allegation of the complainant.
But it was withdrawn through check only.
Yes, that I'm contradicting, Your Lordship. Now,
Okay.
the basic point that I would like to place,
Breach of trust. Huh? Now again alleging criminal breach of trust. Hmm? Did you change my bank register number? Yes. What happened?
now, now she says that I have withdrawn a sum of 10 lakhs from her account and she was
Hmm.
unaware. And this complaint has been filed after a period of more than 3 years, Your Lordship. More than 3 years, 3 years and 3 months to be precise.
He didn't realize that 10 lakhs was deducted from his account.
That is her,
Very rich.
yes.
Okay.
But that is not possible, Your Honor.
Hmm?
That is not possible to believe. Because
Okay.
if it is only about 1,000, 2,000 or 3,000, 4,000, then this you can understand that we may not remain.
Okay.
But deducting 10 lakhs from her account and she was not aware of that.
Okay. What
For
is
a
your
period of-
submission?
Period of 3 years.
It is allegation is against you. What
Yes.
is your submission?
Now my
Stand
submission is that it is a false allegation. Which
false.
she has filed because of her anger. Because she has doubt.
Complaint is okay. Informant is also lady.
Yeah, the informant was a lady and
They are related to.
no, we are not related. The informant and the accused, we are not related to each other.
Okay.
But the complainant, and she has the suspicion that I'm having affairs with her husband since 2017.
Okay.
So to that aspect, she has given one public declaration, Your Lordship, which I have.
So the informant did not give, but then you have withdrawn.
I have not withdrawn, Your Lordship.
Not withdrawn.
No,
Check.
because Your Lordship, Your Lordship will see, if we look at the bank statement of the.
Okay. What is the finding of the police? Char, case
Uh,
registered under
Case registered under
section
379 and charge sheeted under 380.
380.
Yes, with this step.
How it is? 380. Okay. What is the stage of the trial?
It is at the stage of appearance, Your Lordship.
Appearance.
Yes.
Now let us see the finding of the police in charge sheet,
That is in page number 27.
page 27.
Yes, of my,
Relevant. What is the finding?
this is from the second paragraph, Your Lordship. During investigation, Cell visited the place of occurrence and rough sketch map drawn. The complainant Srimati Yakem Ga was examined and recorded her statement, wherein she stated that she used to put her signature in advance at the check in case of any emergency during her absence. And she had also signed the check bearing number so and so APRB Pasigat branch in advance, and that she had kept the checkbook signed checkbook under the pillow in her bedroom. She further mentioned that her husband Sri Tapi Gao had an extramarital affair with the accused Ms. Renuka Tabo. Notice for appearance by the police under section 35(3) BNS served the accused Ms. Renuka Tabo, daughter of Tapi Tabo, residents of Napit Village, POPS Pasigat, East Yang, phone number so and so, and recorded her statement. Specimen signature of the accused obtained for expert opinion. As per the statement of the complainant Srimati Yakem Gao and based on the inquiry report by SI CJ Manche, a notice under section 35(3) BNSS was also served to Sri Tapi Gao. Then
This is in contest.
then
You have
next-
implemented the, okay, we'll issue notice.
now,
Hmm.
even if we look at the check also, if we look at the bank statement of the complainant,
Hmm.
there you will see that all the checks, all the amount that has been withdrawn by check, the check number is given.
Hmm.
But in my in the amount that is purportedly alleged to have been drawn by me, no check number is given.
Hmm. No.
No check number is mentioned. That is page number 34, Your Lordship. 1, 2,
Hmm.
the serial number 4. That is page 34. Serial number,
Serial number 4 is the 10 lakhs.
yes,
No check,
no check number.
but it says that paid to
Paid to Renuka Tabo.
Renuka Tabo is,
It says. But what I'm submitting, Your Lordship, is if I
okay,
had
but then, hmm. Okay, full issue notice, huh?
Your Lordship, then kindly that my interim primary be considered, Your Lordship.
Hard, Mr. Keitaja, and counsel for the petitioner. This is an application filed under section 5 to 8 of Bharatiya Nagarik Suraksha Sanhita 2023, praying for quashing of the Silewayang, quashing of, have you mentioned the GR case number 147/2025, arising out of Silewayang PS case number 17/2025, under section 379 IPC. So why you have mentioned this 380 also? Which one?
Actually, it's 380, Your Lordship.
Hmm?
380.
380?
Because it was registered under 379, but ultimately charged it under 3.
Okay, 380. IPC. Stop, huh? Issue notice since Ms. El Hage, Lanet additional PP. Accepted notice on behalf of the state respondent, no formal notice is required to be sent to the said respondent. Staff, however, the petitioner shall take steps for service of notice upon the respondent number 2 by a speed post address by usual process within a week from today. Stop, para. List this matter. And then a call for the record, huh? Call for the scanned copy of the trial court record. It is pending before which court you said?
CGM Pasigat.
CGM Pasigat, okay. Please this matter after 4 weeks. Okay.
Your Lordship, kindly my interim may be considered.
Hmm?
My interim prayer, Your Lordship.
Interim, let us see the record here in this case. Let us see the record, okay? We'll come after, resume after 4 minutes. Yes,
Matter number 9.
May I please,
Hmm.
Your Lordship? Also, this is an application filed under section 528 of BNS for quashing of an FIR filed before the Itanagar PS case by the FIR number 137/26 under section 316 of subclause 5, 318, subclause 4, 6, 61 to
what is this, 316,
this is criminal breach of trust.
318,
This is cheating and
61?
common intention.
61?
Yes, it's criminal conspiracy.
Okay,
And section 3 is common intention.
okay, there is a party,
Yes.
okay.
Lordship, may I take
Lordship, to page number 23, that is the FIR. Page number 26.
Hmm.
May I read?
Yes, please. It's a long one.
Annexure 3.
Hmm.
Sorry, page number 23, yes.
23.
Yes. Complaint to the Itanagar officer in charge, Itanagar Police Station, dated 15 May 2026. Complaint under section 318, 316 and 61 of BNS oblique 20 BNS 2023 and other applicable provision regarding cheating, criminal breach of trust and conspiracy. Respected sir, I Sri Kyoda Sanjay alias so-and-so, son of so-and-so, presently residing at so-and-so, Itanagar, Arunachal Pradesh, submits this complaint registered of FIR that Sri Hatatu, proprietor of Kenge Construction Co., Sri Anuj Bhardwaj, proprietor of MSAMB Infra Engineer, any other person found involved during investigation, fact of the case. That Sri Hatatu, being the proprietor of the firm, was likely to award a project, namely work service for induction of certain technical units at AF station Tejpur, that is Tejpur, on engineering, procurement and construction of EPC mode. That Sri Anuj Bhardwaj, acting on behalf of Mr. Hatatu, approached Sri Takam Sanjay, proprietor of MS Dontaya Enterprise, to arrange fund for performance bank guarantee for execution of the said project and transfer the work under back-to-back structure of MS Dontaya Enterprise, or sharing 10% profit from the project. That on 12 August 2025, Sri Takam Sanjay informed me, the informant Kyoda Sanjay, and inquiry about the possibility to manage the fund and take up the project. Subsequently, on 13 August 2025, Sri Anuj Bhardwaj, Takam Sanjay and myself had to meet and discuss to manage the fund and take up the work on back-to-back basis from MS Kenge Construction to MS Dontaya Enterprise. That after the meeting on 13th August 2025, I involved my wife, Srimati So-and-so, proprietor of so-and-so, to be a partner in the business with MS Dontaya Tani Enterprise, and consequently the project has been transferred from Don Tani Enterprise to IM developer on back-to-back for effective control and efficient management, and also both agreed and consented that I shall look after the project as a project head on or project manager.
Anyway, the case was registered
Yes, the case has been
and
registered.
then investigated,
Yes,
charge sheet filed.
no, it is in the initial stage. Charge-
This was okay recently.
Yes, recently.
Okay, so you want the FIR to be crushed?
Yes, Lordship. Basically, Lordship, I have, although there is no any provision regarding the reply of the FIR, but I have, this is purely a business transaction between the informant and the alleged accused person. So,
Anyway, we'll call for the
yes,
case diary.
no notice may
Okay.
be issued, notice.
Okay. Had Mr. Titaba, land counsel for the petitioner, also had Ms. Jenny, land additional PP for the state staff. Fair. This is an application filed under section 528 of the BNSS, praying for setting aside and question of the FIR dated
FIR dated 15/5/2026,
registered as Itanagar PS case number
137/2026.
2026 under section 3165. 3184 612 stroke 3 within bracket 5 of the BNS stop para. Issue notice since Ms. Jenny entered appearance and accepted notice on behalf of the state respondent, no formal notice is required to be sent to the state respondent. Staff, however, the petitioner shall take steps for service of notice upon the respondent number 2 by a speed post as well as by usual process within a week from today. Stop. Para. List is a call for the scanned copy of the case diary. Stop. List is matter
On 29th of
on
July.
29th. Okay.
Deeply obliged.
Item number 2, password matter.
There is no limitation.
My lord, may kindly look at
It's 227 only.
131 of the limitation act.
Hmm?
Article 131 of the limitation act.
Article
131,
section 131.
yes, of the limitation act. Article 1.
131.
Yes, ma'am.
What is that? Hmm. But this is 227.
True, my lord.
Hmm.
But still, my lord, in 227 also, my lord, delay has to be explained, my lord. I have seen the,
It's not a delay of 1 or 2 months. It's delay of more than a year. Although specifically this limitation may not be attracted under 227, but then you have to explain why there was a delay.
Lordship,
Where have you explained?
I failed to mention that, but we are not only challenging the impugned judgment order passed by the interblessed
No.
customary, but also we are challenging the executions notice passed by the ESC,
Hmm.
Naharlagan. So it comes under the limitations. And Lordship, this application is filed under,
But basically you are challenging the order, impugned order,
yes, Lordship.
because the execution petition filed after passing of this impugned order only.
Lordship, we haven't received the copy of the judgment.
Where have you stated? You should have stated.
But I failed to mention that, but I have annexed the annexer executions annexer where it is mentioned that the petitioners has not received the impugned judgment order in page 23.
You have to specifically plead.
Lordship, if this application is not admitted, then
This is
there
criminal
will
provision.
be irreparable losses to the petitioners
yes.
along with 3 minor child who resides.
Not connected with minor child now.
But your ship, they are claiming the residential plot.
Yes. Why not? They have paid.
The petitioner is also willing to repay the loan amount.
You repay. Why should you approach the court? Straight away repay or pay back the money. That is what he wanted, it appears.
Petitioner has plead before the interblessed customary court,
You
but
pay. He will not refuse.
Lordship, for that we need some
We
time.
probably have never tried. But struggling, it was on humanitarian ground. That cannot be, because it was paid
It was
at the-
paid to the
at the cost of-
petitioner's
cost of the
husband.
house building. Now, after payment, after having paid, having saved by, no 2%. Who will argue first? You decide first. You file objection then. Will issue notice.
it's not so issued, my lord. And otherwise also, my lord, there is appeal provision, my lord.
No, see, these inter-village doesn't have a power at all. Inter-village customary court. Although the respondent has a case, has a claim, but then this power, this authority doesn't have a jurisdiction.
That is true, my lord.
It has to go.
But then, my lord, they have to, ought to have agitated, my lord.
Yes. Probably didn't realize that. Miss
Atti Anmol.
Anmol, learned counsel for the petitioner. Also had Mr. Kamdu, learned counsel appearing on behalf of the respondent number 1 and 2. Stop, huh? The present petition under Article 227 of the Constitution of India, read with Section 115 of the Civil Procedure Code 1908, is directed against the order dated 15/2/2025 passed by the Inter-Village Customary Court, Nahalagan Circle, and the impugned execution order dated 26/6/2026 issued by the Extra Assistant Commissioner this executing court hasn't passed any order, it appears. What order was passed?
Hearing will be conducted on this coming 10th of this month for execution.
It's not again assistant commissioner, huh? Nahalagan. Stop, para. Complaint was filed before the deputy commissioner. Okay. It is submitted that the inter-village customary court doesn't have the jurisdiction, doesn't have any authority to decide it's a land is what dispute is this?
Residential plot LPC, LPC white number DC
Okay, land dispute. To decide the land dispute under the Assam Frontier Regulation, Assam Frontier Administration of Justice Regulation 1945, or under the Arunachal Pradesh Civil Code Act. And as such, the execution court, pursuant to the order passed by the inter-village customary court without any jurisdiction, is also without any authority. Stop, para. Sorry, it is further submitted that before passing on or passing the impugned order, no opportunity of hearing was also given to the petitioner. Stop, issue notice returnable by 4 weeks. Para, since Mr. Kamduk, Learned Counsel put appear and accepted notice on behalf of the respondent number 1 and 2, no formal notice need be issued to the said respondent. Stop. The petitioner shall take steps for service of notice upon the respondent number 3 by speed post as well as by usual process within a week from today. Stop. Para, call for the record is necessary to be called for. Mr. Kamduk? It was before the DC will call for the record.
Yes, ma'am.
We call for the record, relevant record. Stop, para. List this matter after 4 weeks. Stop, para. In the meantime, and having considered the contention made, it is provided that the operation of the order dated 15/2/2026 as well as the execution proceeding. Where is the number before the court of the
Lordship, page number 23,
before the executing court page?
23, 23. Annex 2.
Before the execution proceeding before the Assistant Commissioner Naharagan shall remain state till the next returnable date. Okay?
Much obliged.
Item number 5, passover matter.
May I please your lordship?
Hmm.
Lordship, this is anticipatory bail application.
Hmm.
In respect of the lordship case, which was registered being SIC Vigilance. Lordship, I'm
Yes, FIR is that.
yes. Initially, lordship.
This is AB.
Yes, anticipatory bail.
Hmm.
Initially, complaint was lodged by one Sri Posam Jongsam, who was the BJP Mandal president of Changlang district. He was, complaint was filed before the deputy commissioner regarding non-properly implementation and execution of the PMJSOA road lordship within the Changlang. So basically, it was against the department executing agency lordship.
Hmm. Complaint before the deputy commissioner.
Yes, lordship.
This was forwarded to the police.
Yes, deputy
It was
commissioner.
registered.
Yes, it was.
What is the allegation specific?
Allegation, lordship. May I take you to the complaint, lordship?
Hmm.
Page 21, lordship.
Hmm.
Complaint regarding care of road from CK Road to Waltom, Tamyang, Stage 2, package number so and so, PMJSY Phase 2, and CK Road to Jongpo Hate under PMJSY scheme, lordship. Now, there are two schemes, lordship. With due respect, we the undersigned would like to bring to your kind notice regarding the gross irregularities and
Not been.
negligence in the implementation of PMGSY Road construction project under DIFU RWD Division Changlang. The two vital projects undertaken by RWD PMGSY Changlang these are the two project road lordship. Both these projects have not been completed within the stipulated period, and the progress remains unsatisfactory despite repeated concern raised by the public and local stakeholders. The lack of proper monitoring, poor execution, and misappropriation of government funds have led to hardship for the residents who are supposed to benefit from essential connectivity project. The first project is mentioned above at point number so and so, Waltham Stage 2, under DIFU package number so and so, PMGSY Phase 2, has also physical work achievement of 2 kilometers and found remaining as per verbal official information is only rupees 30 lakhs out of total amount. Secondly, the said project CK Road to Jongpo Hate under PMGSY scheme DIFU 1 has also remained incomplete with only 50% blacktopping done, whereas the department has issued completion certificate against the same project. Several verbal and written complaint has been made to executive engineer, but no substantial action has been observed, which reflects a serious lapse in responsibility on the part of the implementing agency, particularly the then concerned department officers and officials of RWD Changlang Division, Government of AP. The delay not only affects development progress, but also undermines the interest of the government's flagship PMGSY Road scheme meant to improve rural infrastructures. In view of the above, we earnestly appeal to your good office to initiate a thorough inquiry into the matter and take necessary action against.
Okay, what happened thereafter?
Now, thereafter, Lordship, it
Yes,
was
registered.
Yes, it was forwarded to the Deputy Secretary Vigilance, Lordship. Now, pursuant to that letter, forwarding the Vigilance Authority Officer Secretary issued an order for preliminary inquiry, Lordship, to the police officers of vigilance. Now, pursuant to that order, Lordship, preliminary inquiry was carried out by the SCB team.
Okay.
And thereafter, report was submitted on.
What the report says?
Report says, Lordship, conclusion portion, may I take you to the page 25? Is the preliminary inquiry report,
Yes,
Lordship.
yes.
And conclusion, Lordship, may I take you page 33, Lordship? 3.
Okay.
Yes, point number 6, Lordship.
Hmm.
Conclusion of the preliminary inquiry, Lordship. Page 33, Lordship. Based on the facts mentioned above in point number 5A to G, I find the instant matter a pit case for registration of FIR in order to initiate detailed investigation and unearth the specific roles of engineers, officials under DIFU Changlang in the irregularities observed during execution of both the project in question. Prima facie against the allegation made in the complaint appears to be true. Now, Lordship, on this finding, Lordship, again, order was issued on 13/5/2026 for registration of regular case, Lordship.
Okay.
Accordingly, it was registered as ACB PS case number 4 of 26 under section, Lordship, 120B, 409, 420, 467, 471 IPC, read with section 13(2) of PC Act, Lordship. Now, Lordship, the applicant before your Lordship.
Now this, when ultimately it was registered?
It was, Lordship, order was 13/5 issued on page number 39, Lordship. 39 is the order.
May 26.
Yes. Yes. Yes.
How many accused persons are there?
Lordship.
How many accused persons are there?
Accused, Lordship, as per this preliminary inquiry, Lordship, will find at page 32. Here, the list of officers of the department has been, who was alleged to have been involved in this work.
Your name
project.
here at,
My name is at serial number 6, Lordship. Nirmal Chaudhary.
Hmm.
Lordship, this Nirmal Chaudhary, the applicant before your Lordship is now he's retired, Lordship. During that point of-
who is retired?
the present applicant, Lordship.
Applicant.
Yes, Lord.
What he was?
He was the cashier in charge, did to Lordship, he was the in charge cashier in the department since 2020 to till the retirement, 26, Lordship. Now, Lordship, the allegation here is, Lordship, the offense register is, Lordship, 120B, criminal conspiracy, 409. Criminal conspiracy B, Lordship, is aware it's subject to the trial. But 409, criminal breach of trust. 420, cheating and dishonestly inducing delivery of property. 467, forgery of
Okay.
valuable security.
Okay.
472.
Yes. So,
In the same matter, my lord, the CDS will call for, my lord.
call for,
Yes, my lord.
Well- okay, 20?
Right.
Okay,
Yeah.
check up together. Pardon me, Mr. Lawley. Learning counsel for the, Lawley, learning counsel for the petitioner. Also heard Mr. Opada, learned standing counsel for ACB. Para. By filing this application under section 482 of Bharatiya Nagarik Suraksha Sanhita 2023, the petitioner is seeking grant of pre-arrest bail in connection with ACB PS case number 04/2026 under section 120B, 409, 420, 467, 471 IPC, read with section 13(2) of PC Act 1988. Issue notice, since Mr. O. Padala, Standing Counsel, ACB accepted notice on behalf of the respondent. State respondent, no formal notice is required to be issued. So, call for the case diary, scanned copy of the case diary stuff. It is submitted that similar case is pending before this court, which is being fixed on, which is fixed on 21st. And prays that this matter may also be listed along with the, you have the number.
My lord, yes.
Okay, okay, on 21, it's fine, okay, on 21. Similar case pending this court, which is fixed on so and so, where the case scanned copy of the case study has been called for, and by fixing the next date on 21/7/2026, stop, and view of the above, and as press for common list this matter also on 21/7/2026. Okay.
My lord, entry number 70.
It's fine on that day. Okay, then right number of case 20. Okay, 73 of 2026.
My lord.
Okay,
Lordship, I am
Please
praying
allow.
for interim protection, Lordship.
We'll see the record.
Lordship, till, because he is also, there is no chance of, now he is already retired. So the question of, he doesn't have any connection in the office also. There is no possibilities of temporary. In fact, the allegation is purely for irregularities in work execution. My duty was only to, Lordship, release the fund of the department.
You were working as
Case,
in
charge case letter.
in charge cashier.
Yeah, and I had to retire on the same post.
Hmm.
So I have no role in the work site visit, preparing of MB.
Let us see what is the allegation.
Lordship,
Hmm?
please,
That
Lordship,
will come out only after the CD.
Yes.
my lord.
Let us see the
at least,
CD.
Lordship,
See,
No court.
what is the amount involved here?
Among, my lord, there are two projects, my lord. One is,
It's a project.
yes, project, my
two
lord.
projects.
Okay, no.
6 and other one is around 3.
Okay, no.
At least
Sorry,
lordship, no courtship till.
No, no. Project. It's very difficult to convince ourselves, no? In the project, so many things are happening.
Yes,
It's
lord.
very
There
difficult.
are the engineers.
Not even a
who-
small.
Who execute the work, under which
Engineer
guidance.
also will not be spared.
Yes, lordship.
Mm.
My role and duty, lordship,
Mm.
and
Otherwise, his role is limited on the
Yeah.
direction only.
Yes,
They
yeah.
used to work.
yes,
So
lord.
let us see, you don't worry then.
They may.
Police also probably, they don't want to arrest, probably till now, not yet been arrested.
Since all
So
the,
why should you aggravate?
all the offense are lordship non-bailable.
Maybe, but then not yet arrested. That means it indicates that you are not wanted or
Therefore, lordship, till next.
not
only
required
no-
to be arrested.
Only no courtship, lordship.
Hmm?
Only no courtship, lordship. Till next day, city lord.
The, what is your submission?
If lordship in city.
No.
Anything.
So now, once no coercive is issued to one accused, the other will claim the same, similar order. No. Okay.
Item number 10,
Deeply obliged.
This is 10. This is 10.
May I please, your lordship?
Yes.
This is a application, criminal petition application filed under section 528 of BNS in connection with WP Itanagar Women Police Station case number 25 of 2020 and criminal proceeding GR case number 177 of 2020. And sections are 498A and 325 IPC. Here, 325 IPC is voluntary causing grievous hurt, which is a compoundable, your lordship, and 498 is a cruelty against wife. This is not compoundable, and has a imprisonment of 3 years. Here, your lordship, both the parties, the informant and the accused, the husband, they have amicably settled and living peacefully since for last 6 years. With their
This,
3 minor
this
daughters,
complaint, this was filed on
your lordship. FIR was lodged on 14/3/2020, your lordship. That is in annexure to page number 15.
they are staying together now.
Yes, your lordship.
Having
They are
children?
staying, with their children, your lordship. There are no any issue after that, no further any complaint, nothing. They are living very peacefully.
Charge sheet filed?
Charge sheet filed, your lordship. And
Why we were waiting for then? Charge sheet to file?
no, your lordship, there is a 498A is a non-compoundable case. They have
Well, okay.
complaint and
Then what happened? Trial begun?
now your lordship, trial is being endorsed before the learned JMFC 1 UPR, your lordship. It was endorsed on 6/12/2025. It's pending, your lordship. Trial proceeding is pending, your lordship. Charge sheet already filed on in the year 2022, your lordship, which I have annexed here. I pray that your lordship, this is a very fit case where your lordship can interfere by terminating the criminal proceeding arising out of Omen PS case number 25.
Now, after charge sheet filed, what happened thereafter?
After charge sheet file, the charge sheet file
Trial?
have not yet commenced, your lordship. It was endorsed
When charge sheet was filed?
2021, your lordship.
2021.
Okay, trial not yet began. Which
Not
court?
yet begun.
It was-
Learned JMFC 1 UPR.
Not yet begun.
Yes, your lordship.
Why?
No, it was forwarded to JMFC in the year 2022, your lordship. It was endorsed. Your lordship will find it at page number 47.
40?
47
is case settlement.
No, in my page 47 is 40.
46 is order
Yes, 46. Mine is
18/12/2025.
yes. No. तुम page nation अच्छा से नहीं क्या? My 47 shows an order dated 14/9/2022 where the matter was endorsed from CGM's court to JMFC court UPI, your lordship.
Page?
Page number 47 in my
Okay,
petition.
so Mr. Bhattacharya wanted to confuse everyone.
No,
by giving
but it should be for
separate, the different set of
Your Lordship will,
petition.
it should be the second last page, Your Lordship. Your Lordship will find in second last page.
Yes, second last page is page 46.
Yeah.
And it is order dated 18/12/2025.
Mine 18/12/2025 is at the page number 14, Your Lordship. Your
Page
Lordship, he
14.
may correct the same, Your Lordship. This is not. My annexure 1, page number 14 is the order dated 18/12/2025.
Annexure one is the endorsement, Your Lordship, of the trial proceeding before the JMFC, Your Lordship. But that is annexure one, page number 14, Your Lordship.
This is 18/12, this is also 18/12/2025.
18,
Page
12,
46 also 18/12/2025. What is this?
46. Page 46 is the last part of charge sheet, Your Lordship.
No,
The
46
49,
is the,
2022. It was,
46 is,
case was put up, Your Lordship.
no. You, I think, probably need to correct. So, what is your submission? Let him,
Submission, Your Lordship.
let him correct the page number. Page number.
I'll correct it, Your Lordship. But
Hmm?
here I will, this is a very big case, and Your Lordship already knows Lakshmi Narayan case. This case doesn't come under heinous crime or any economic offense.
Yes,
It's only
Nick,
relating to
Your
matrimonial.
Lordship, Your Lordship, I'll just clarify, Your Lordship. The case was put up before the JMFC court in the year 2022, Your Lordship, as per,
it's 25.
no, 2022. He is also is
Yes.
2022.
Yes,
Your Lordship, here
Except-
I,
page, page
Just-
14 and then page 47, 46.
Except for Your
Same.
Lordship's copy, both of our copies are same, Your Lordship. Except for Your Lordship's copy, both of our copies are same, Your Lordship.
You want to eliminate that.
Your Lordship,
Uh,
I have mistakenly, I think I annexed.
This was,
Same-
this
same-
was meant for her. You mean
No,
to
Your
say?
Lordship, the CTC copy is with me, but
Ah.
mistakenly while filing.
Then
I
the,
apologize. Your
Okay,
Lordship. I'll
well,
correct it. This is only.
Yes,
one
yes,
page.
let her submit.
I'll just clarify this entire
Mm.
issue, Your Lordship. 2022, it was endorsed to JMFC, and perhaps thereafter the case proceeded, Your Lordship. In this order dated 18/12/2025 is, since there are two JMFCs now, Your Lordship. One of the JMFC has forwarded the case record to another JMFC's court.
Okay,
This is
having
the-
jurisdiction.
this is the both, these are both the orders.
Hmm.
Now, Your Lordship, I would request the Lordship to direct for the call of the record. While I'll tell Your
For
Lordship.
confirmation.
Yes, because in a very recent incidents, the council had come saying that the parties are married, Your Lordship.
Hmm.
And subsequently, there were issues with regard to another accused also being a part of, not being the part of the settlement, but part of the case, Your Lordship.
Mhm.
Also, there were cases where both they claim to be husband and wife, but then as soon as the matter completed before this court for questioning, Your Lordship, it was revealed that they are not staying together anymore. I just
Oh.
wanted to ascertain with the stage, at least with
Miss-
regard to TC.
Obtain order by
Maybe-
misleading.
Yes, because Your Lordship will see neither of the IDs are produced nor marriage, because if it is done in customary court, Your Lordship, we are not
Actually,
certain.
the parties should also be called.
Yes.
Hmm.
It's very
in such
unfortunate,
cases.
yes, Your Lordship.
We actually have absolutely no reason to disbelieve the council.
Yes.
But then if the council
Parties-
started doing that,
Mhm.
then there will be no reason to believe the council.
No, Your Lordship, here
And
the
unfortunately. we
settlement
have
agreement is a
recently
very
encountered-
recent agreement, Your Lordship. That is on 10th day of June 2026.
Anyway, we'll call for the record.
Your
I
Lordship,
don't have
this
any,
is a very-
I don't have
Due to
any,
pendency of this case, Your Lordship, petitioner number one, the accused
Okay,
husband is
since
facing
2020,
difficulties, Your
since
Lordship.
2020,
He's-
more than 6 years. Now you are taking urgent within this 5 minutes.
Your Lordship, earlier they have.
Wait
even-
for some days.
No,
Wait
this,
for few
petitioner
more
number
days.
two have even.
Will grant
went to
you.
The Omen Police Station, Your Lordship,
Hmm.
and she requested to withdraw the case only because.
Where is that record?
No, see, Barveli went and
See,
498.
this Barwell is
But
very
here, Your
difficult in the
Lordship,
court.
This is a very simple case.
I don't have
If
objection
any
in-
Okay,
subsequent
no
appeal
objection,
come,
okay.
If fine.
Okay, you will be
legal
granted.
action can be taken against
Okay,
me.
you will be granted. But
I
wait.
have applied the certified copy. Whatever I have received from the JMFC GR.
Heard Mr. Bhattacharjee.
So I
and
pray
counsel
that
for
your
the
lordship,
petitioner.
this is a very fit case here. Very
Also heard Ms. Ginny Lanet.
offense are very minor, your lordship, matrimonial dispute.
This is an application file under Section 528 of the BNSS, praying for quashing and setting aside of the criminal, the GR case number. Give the number. Where is my brief?
177 of 2020.
2020, arising out of which PS case?
The Itanagar WPS.
Itanagar Women PS case number
25 of 2020.
25 was done, 2020.
Yes. Under section 498A.
498A.
Oblique 325 IPC.
325 IPC. Pending before the court of the judicial magistrate first class.
One. There are nowadays, your lordship, there is a
Which court?
JMFC 1.
One is for Nahalagan.
UPI, JMFC 1.
JMFC 1, UPI. No, there must be, one is for the one JMFC is taking up the matter of the Itanagar and another is for Nahalagan.
They have, your lordship.
One is for?
One is for Capital Complex, your lordship. The other is for UPI. Because the.
Okay. Capital Complex is the Itanagar and Nahalagan.
Yes.
One is UPI.
One is UPI.
So it's,
No.
it's
Altogether,
JMFC
your
1.
lordship, there are 3 JMFC in there.
Oh,
One
3?
JMFC 1, 2, and 3. JMFC
Yes.
3 is the designation is judicial magistrate first class, Nahalagan.
Okay.
But court proceeding is at UPI.
No, all will be probably at UPI.
Yes.
JMFC 1.
JMFC, the trial proceeding which going to commence, it is endorsed before JMFC 1. Number 1.
Okay.
Junior.
Staff.
Junior division.
Issue notice. Since Ms. Ginny appeared and accepted notice on behalf of the state respondent, no formal notice is required to be sent to the state respondent. No private respondent.
No, yeah,
Okay. Okay.
The
Joint
petitioner, one
petition.
is only one.
Okay, no problem.
Another one.
Okay, call for the scanned copy of the case diary. Staff and list the matter again on
31 July. हम लोग का
23
केस है.
or 21, 23.
Election petition is there.
Okay, 21.
Yes.
Okay, 21 July. Okay.
Your lordship, then pending pendency.
In the meantime,
your
the
lordship. Earlier, if
the proceeding
proceeding at least
of the
anytime,
GR case number, GR case number, give GR case number
177
before the judicial magistrate first class 1 shall remain stayed till the next returnable date. Okay. Offline.
Item number 11.
Naples, my lord.
Yes.
My lord, this criminal petition is jointly filed by the petitioners to passing and setting aside FIR dated 22/12/2025, registered at Papu Hill PS case number 115/2025 under section 305 closed.
Let us see the allegation.
Allegation is, my lord, actually, my lord, the petitioners are the father and son, my lord.
Father and son.
Father and son. The allegation is.
Who has lodged against whom?
Father lodged the complaint against the son. The allegation is, my lord, the son, that is petitioner number 1, broken the window and Godrej Almira and taken away case amount of rupees 9,20,000, along with 9,20,000, along with 2 notes of mobile handset without his consent and knowledge.
What is the age of the son?
Son is 22 years, my lord. And
okay,
accordingly, he was lodged FIR against his son because only because of misunderstanding, my lord. Actual fact of the case is, my lord, on 15/12/2025, petitioner number 1 called his father, and it's around 11:30 a.m. Asked him for money to buy a motorbike and an iPhone. On that day, the petitioner number 2, who is the father of the petitioner number 1, he was busy actually in the official duty. So he informed the petitioner number 1 that he would call him back later. Unfortunately, petitioner number 2 forgot to return the call without any ill intention and whatsoever. But on 18/12/2025, the son, petitioner number 1, came to the Naharlagan to meet his father at his rented house situated at Papu Yarda colony. Upon reaching the house, he found that the house was locked, and then he was attempted to contact his father over phone, but his father did not answer the call. So the son, petitioner number 1, mistakenly believed that his father has intentionally avoided him. Out of anger and frustration, he entered the house through the kitchen window. Upon checking the Godrej Almirah, which was found unlocked, he took away cash amount of
So what thereafter? Charge sheet filed.
charge sheet filed, and
What
now the case is pending before the learned JMFC Naharlagan
For CC.
for CC.
Okay.
Now,
Agreement between father and son on
yes,
18
already,
June.
yes. So since
What the son is doing now?
he's doing, now he's doing nothing. Actually, he's dropped out from the school also, Your Honor, because of the only bad company friends. So he's not listening and to his father. So,
Father cannot purchase good company.
my lord,
Anyway, so what do you want?
Lordship, it's, it have to be father and son, lordship.
So we close?
Yes, lordship.
Okay. Had Mr.
Jitadi,
Jitadi, non-counsel for the petitioner. Which court it is pending?
JMFC Naharlagan.
Nahalagan.
Yes, my lord.
JMFC Nahalagan is located at Nahalagan
No,
itself?
no,
UPia.
UPia.
Okay. Also had Mr. Loilana PP for the state staff. This, no, we will continue at 2. This will dispose of, okay, dispose. Allowed, huh?
But lordship, sometimes stated by the submitted by TJ, sometimes some the petitioner not come with clean hand. That's why we.
So this is father and son,
This is father and son.
not the husband and wife.
Yeah, that's it.
At least.
Yeah, yeah.
Item number 12.
My lord, it is a joint petition filed under section 528 of Bharatiya Nagrik Suraksha Sanhita, BNSS 2023, seeks quashing of charge sheet number 29/2023, dated 17 July 2023, arising out of Papu Hills PS case number 07/2022, registered under section 279/338 of the Indian Penal Code 1860, pending before the learned judicial magistrate first class at UPia. My lord, the fact of the case is that on 28 February 2022, the applicant number 3 lodged a written FIR before the officer in charge. The petitioner number 3 lodged a written FIR before the officer in charge, Papu Hills Police Station, that his younger brother Sri Hai Tau had been hit by a Tata mobile vehicle bearing registration number AS07C 5507 at Nyorch, UPia, while he was heading towards his residence at Doimuk in his scooty bearing registration number AR022418. Thereafter, he was immediately brought to TRIMS and admitted him in unconscious condition, and moreover, his knee was dislocated in the accident, and he also suffered injuries to his eyes. As such, on the basis of the said FIR was registered by Papu Hills PS case number 07/2022
My lord, kindly come to page number 13 and 14.
Okay,
May I read the FIR?
okay.
Uh,
What is 338?
338 and 279.
Okay, what is 338?
338 is negligent and rush driving.
Okay, which one is non-compoundable?
279 is non-compoundable.
Okay. What happened thereafter? Charge,
Charge sheet has been filed.
charge sheet filed. What is
Yes,
the
but
status of
the
the file?
charges are yet to be framed.
Charge yet to be framed?
Yes, next
Not
date
yet
has been
framed.
fixed for OE.
Hmm?
Next date has been fixed for OE on 14 July
Next date
2026.
fixed for?
OE, offense explanation.
Okay.
Charges are yet to be framed. And my lord,
Party have settled.
yeah, the matter had already been settled by both the parties
Oh,
mutually and amicably through local Kebang meeting on 7 June 2022 itself.
whether the
And as per the mail,
victim, injured person has adequately been compensated? Where?
yes, my lord,
Where do we find?
it is annexed as annexure 3, page number 35 to 38, my lord.
Okay, page 6 lakhs.
The petitioner number 1 had had paid a sum of
Is
rupees.
injured case only?
Yes, Lordship.
Yes, my lord.
And they have already settled the matter way back on 2022 itself, Lordship.
Okay.
The year of
And
When the incident took place, 22?
incident, yes, Lordship, the same year, Lordship.
Okay.
and they had given rupees 6 lakhs as compensation amount and bore all the medical expenses. So, my lord, it is therefore prayed that your lordship may be pleased to admit this petition and quash and set aside the GR number 17422 in Papu Hills PS case number
Where is the
07
last order
2022.
passed by the court, trial court?
My lord, it is in page number 39, annexure 4. My lord, a copy of order dated 24 June 2026 is annexed herewith and marked as annexure 4. Kindly come to page number 39, my lord.
Yes, okay. So you have any objection?
Oh, no, Lordship, they have already settled.
Can we
Lordship.
dispose of? Yeah?
And the compensation already compensated also.
Okay. It's an accident case only,
Yes, sir.
injured,
Yes.
not the case of death.
Yes, Lordship.
Okay. Hard miss,
G. Pina.
G. Pina. Land counsel for the petitioner. Also had Ms. L. Hage, land additional PP for the state respondent. Which one is the accused among the petitioner?
Accused is petitioner number 1.
One is accused
Yes, my lord.
and 2
2 is victim,
and 3.
complainant.
Okay. This, the present petition under 528 of the Bharatiya Nagarik Suraksha Sanhita has been jointly filed by the accused and accused stroke victim and informant in which PS case? Where do we find that? Which PS case?
Kamitana.
Papu Hill Police,
Papu Hill
Police Station case. Number,
07 2022.
where do we find? 07/2022.
Page 1. Page 1, Lordship.
Okay. Praying for setting aside and quashing of 338 and 279 of the Bharatiya Nagarik Suraksha Sanhita. Has been jointly filed by the accused and accused stroke victim and informant in which PS case?
Kamitana.
01/2022. 01/2022.
the GR case number 174, 2022, arising out of Papu Hill PS case number 07, 2022, under section 279 stroke 338 IPC. Stop. Huh? IPC pending before. Which court you said? Judicial Magistrate First Class?
UPIA. UPIA.
UPIA.
Judicial Magistrate First Class, UPIA lawsuit.
UPIA.
Yes, lawsuit.
The other one is named as Judicial Magistrate First Class?
Nahalagan.
This was Nahalagan lawsuit.
Nahalagan.
UPIA lawsuit.
And you said that three, yeah, there are
Yes,
three
yes,
judicial,
yes.
and the third one is
Judicial Magistrate First Class 3.
First Class?
3, UPIA 3. Judicial
UPIA 3.
Magistrate, yes.
Okay, so this is UPIA.
JMFC 3.
Okay, this
UPIA.
is, okay. No, yeah, it's only yes. Hmm. Okay, stop. Huh? The petitioner number 1 is the accused. 1 Sri Rajiv Miri is the accused. Semicolon. The petitioner number 2, Sri Hai Tao is the victim, and the petitioner number 3, Sri Taru Hai is the informant in the aforesaid PS case number 07/2022. Stop. Tara. The case leading to the filing of this criminal petition is that on 28/2/2022, a written FIR was lodged by the petitioner number 3 against the petitioner number 1, alleging that on February, on 28/2/2022 at about 9 p.m., the Tata Mobile vehicle bearing registration number AS07 AC 5507 at Notch hit the petitioner number 2, causing dislocation and damaging the right eye. No, just a minute. Right eye also. Right eye of the victim. Huh? Stop. Based on the aforesaid written FIR, comma, the based on the aforesaid written FIR, comma, the aforementioned Papu Hill Police Station case number 7/2022 has been registered and investigated into. Stop. Para. No, it's continue. Stop. Upon completion of investigation, the police has submitted charge sheet against accused petitioner number 1 for commission of offense punishable under section 279 stroke 338 IPC. Stop. On just IPC on when the charge sheet was filed.
Charge sheet. कौन सा डेट में था ना? 17 July 2023.
17/7 charge sheet number 29 stroke 2023 on 17/7/2023. Stop. The learned magistrate took cognizance of the case and the case is now pending trial before the court of, before the judicial magistrate first class, UPR, for what is this you said? OE, what is this OE?
Offense explanation.
Okay, for offense explanation. Fixing next date, 14/7/2026. Stop, para. The Learning Council for the petitioner submits stress during the pendency of incident took place on 22. It was settled in the 22 years only. Submitted that immediately after the occurrence of the incident, the parties have already settled amicably settled the matter by executing a deed of settlement on dated 11/6/2022. Where?
7/6.
Hmm?
7/6.
Seven.
7/6, yeah, 7/6/2022.
Okay, 7/6/2022. Wherein the sorry, just stop, huh? In the said deed of settlement already paid or it was promised to pay?
Already paid.
The content of the settlement includes that the accused petitioner number 1 has borne the entire expenditure for the treatment of the victim petitioner number 2, and also and beside and above all also paid a sum of rupees 6 lakhs as a compensation to the victim. For the injury sustained by him. Stop. The said settlement was informed to the IO of the case. However, since the offense registered against the accused petitioner number 1 was non-compoundable offense, the case proceeded for investigation, leading to filing of the charge sheet against the accused petitioner number 1. Stop. Para, it is submitted. The Learning Council for the petitioner submits that since the case has amicably been settled, the victim has adequately been compensated by paying adequate compensation to the victim, the further proceeding of the criminal case against the accused petitioner would only cause harassment to both the parties. Cause the parties, and there is no any scope of the of conviction in the, just a minute, leave that. There is no scope of conviction in the case, and the trial and the further proceeding of the case would only cause harassment to both the parties. and would amount to abuse of the process of law, Stava Para. Therefore, the petitioner prays for, and the petitioner further submits that the dispute is an individual in nature and doesn't affect the society at large. Therefore, we praise that the proceeding against the accused applicant number 1 be set aside and quashed for interest of justice. Stafkar. Ms. El Hage, Learned Additional PP, clearly submits that and the summits that in view of the deed of settlement, in view of the matter having amicably settled between the parties and by executing a deed of settlement dated 7/6/2022, and also considering that the victim in the instant case has adequately been compensated by the accused, she has no, and also considering that the informant and the victim does not have any further grievance against the accused, and they does not want to pursue with the matter any further. She has no objection if the claim, if the prayer of the petitioner is allowed. Staffer. In the earlier also, this no further grievance need to include. Heard both the Learned Counsel for the parties also peruse the record. Then my order will be completed. Okay. So dispose of. Okay.
Highly obliged, my lord.
Matter number 13.
May I lordship?
Yeah.
Main counsel is absent today. He's out of station. So,
Okay.
so this matter may be kindly fixed for another date.
Okay. What is this case? You are there?
I don't know about the facts.
Lordship, it is gang rape, Lordship, the wrongful restraint, kidnapping, and under section 6 of POCSO, Lordship.
Okay.
And
Oh,
they
okay.
they come with the settlement, Lordship, which is not permissible.
Oh, okay. It is submitted that. Mr.
T. Marwam.
Learned Counsel submits that the mayor, the conducting counsel for the petitioner is Mr. So appearing on behalf of the Learned Counsel for the petitioner, prays for listing this matter after the vacation. Prayer allowed. List this matter after the vacation, ensuing summer vacation. Okay.
Highly.
Matter number 14.
Yes. What is this? None appears for the.
My lord, he's here. I'll just.
I'm sorry, my lord. My lord, in the last occasion, the updated PCR was called for.
Okay. DC.
In
What case is this?
abatement of suicide, my lord.
Okay.
Day
abatement.
before yesterday, my lord had
Okay,
heard my submission at length.
Okay. So,
My lord-
what is the progress of the trial?
My lord, 7 prosecution witnesses have been examined
Out
till
of?
date. As per the 161, there were 8 prosecution witnesses when the charges were
Almost
filed.
complete.
And some doctor. My lord, I have researched after that day before, after that my argument. My lord, my concern of filing this criminal revision petition was, my lord, in my humble understanding of the law, my lord, I have challenged the impugn framing of charge of order of the district session judge UPA. So whatever has transpired after that, that is at the stage of evidence, my lord, in my humble understanding of law, that will not affect whatever argument I'm placing at this criminal revision petition, my lord.
See, you say that out of 9 prosecution witnesses, 8 have been,
Seven.
or 7.
My lord, there are
Yes,
some
out of 8,
state
7 have
witnesses
already
also.
been,
There are state witnesses also, doctors and IO.
they are
have not-
official witness. Official witness.
Official witness, my
Yes,
yeah.
but then say under it means almost the trial
My lord.
almost concluded.
I understand, my lord.
But see, at the rightly or wrongly charge framed.
Yes,
But then it was on the prima facie finding that there is some material against
my
the
lord,
accused person.
my lord.
So now at this stage, it appears that the trial court would be the right court to decide at this stage, because almost completed the
My-
material. So because this court will not examine, not appreciate the evidence.
My lord, I
As
have
in a
not.
case,
I have
like
not,
a
because
trial court.
trial court has also come to this finding only on the basis of the 161 statements of all this.
No, now it is, now the evidence is available.
Yes, my lord.
Now, can this high courts appreciate the evidence evidence
My
recorded by the
understanding
trial
of
court?
law, my lord, High Court can still interfere, because this being a criminal revision petition, the order,
See,
the
now-
charges has been framed on the basis of the material placed on evidence at that time,
Yes, that is what I'm saying.
my lord,
So at that time, there was a prima facie case.
my lord,
Now, the entire evidence except for one has already been recorded,
my lord,
evidence adduced.
my lord,
Now it is available with the trial court.
my lord.
Now trial court will be able to appreciate the evidence available by now,
My lord,
except for one.
my lord.
Now, will this court, whether if it were the case that where the charge were not yet framed, etc., okay,
My lord.
could have. But then now, since the evidence is available, whether this court will appreciate.
My
The
lord, we have
evidence-
to see only at the stage where the charges were, how the charges were framed. That is why, my
No,
lord, this criminal,
thereafter subsequently it has come. Subsequently, the evidence has already been adduced.
my lord,
So that is what I am saying. Now, the evidence is available.
my lord.
Now, whether the framing of charge was right or wrong, it will decide.
Now, my lord, I ask myself whether that evidence stage will have any bearing on this criminal revision petition, whatever has been subsequent development. That is, I ask.
Now, when the evidence is already available,
My
now
lord.
can we neglect? Can we discard? Can this court discard the evidence available?
That cannot be, my lord.
Yes.
However, my lord, my prayer is, I am only challenging that framing of charge. I know, my lord, the subsequent development prosecution witnesses are still at, pending. There are already 7 witnesses have been examined. However, my lord, whether that
Now
the
see-
prima facie that conclusion, observation, and the opinion, and under which this charges of 306 and 34 IPC has been charged against me, whether they apply to me or not, my lord. That is why this criminal revision petition, man. At any stage, my lord, I believe when I file it, and I can show
That is
the
that is
grounds.
why this was proceeded.
Yes, my lord. And at the time of filing of this civil revision petition, my lord,
Criminal.
yes, criminal revision petition, my lord, I have not pressed for interim because I don't wanted to delay the trial proceeding, my lord. If I had obtained interim protection from this honorable court, then all these witnesses will be called again if my criminal revision petition will be dismissed. So that is why, my lord, I have not pressed for the interim order.
That we appreciate.
I am
but then-
fully cooperating with all these stages.
Yes, for that we appreciate. But then at this stage, unless the evidence, because the evidence is already available with us,
Yes,
the
my
entire evidence. Now, unless the evidence is appreciated, how this court?
My lord, the moot
But then
point
this
is
court
whether
again
the
will not
charges
enter
framed
into the
against
evidence.
me, the charges framed against me, whether are they attracted to me or not. That is the only moot point, my lord.
So
Any
at
stage,
the-
my lord.
At the time of framing charge.
My lord.
Just I assist my brother.
Mhm.
This is a revision petition under
397,
397,401.
Mhm.
Even if the evidence
Hmm.
is on the verge of final stage,
Mhm.
if the petitioner can demonstrate, my lord,
Mhm.
there is a patent illegality
Mhm.
at the time of framing of the church,
Mhm.
this High Court has a power still.
That is true.
That this High Court has.
That is true. That is why it has proceeded.
Yeah. That's why, therefore, my lord,
Hmm.
if my brother
Hmm.
from the record can show that there was a patent illegality at the time of framing of the charges, this honorable court has a power under 397.
That probably is not his period case.
Ah.
It's only that there was no prima facie. But whereas the court has observed that after observing that there is a prima facie case found against the accused for framing charge under section so and so. So that is there. And then he is challenging that, not the illegality.
Okay, that is one thing.
Hmm.
Then second aspect, this court need to take consideration whether the court, the learned trial court,
Hmm.
had applied the mind or not. Because suppose that at the time of framing charges, we file application under 236
Hmm.
for discharge, whether it is a session court or the thing. Because there, my lord, has to appreciate that at the time of framing charge, learned trial learned magistrate should not act as a post office. He is duty bound to evaluate all the materials available before him or her. So if there is anything on this ground, my lord, has still the power. There is a shortage of time, otherwise, my lord, I could have assisted. But I remember
Yes, thank
some
you.
judgment that some juicy judgment is there,
Mhm.
where this court has a power still. If this court finds that prima facie there is illegality, and then at the time of framing of the charges, if the ingredients are not met, but the learned trial magistrate proceeded with the framing of the charges, then also this court has a power to interfere.
That is why this was proceeded actually. Thank you.
Let me see, I just, if I can.
Thank you.
Thank you, sir. My lord, I will just humbly pray that, my lord, the another submission is whether there is a chance of any chance of conviction of the petitioner in this matter also, my lord, for the ends of justice, my lord, and for securing the ends of justice. My lord, I will not take much time. I'll just pray that whether there's any chance of conviction also, my lord, that also needs to be understood, my lord. So, learned PP is there and legal aid counsel. I'll submit up if anything.
Yes.
If now the trial is at the verge of completion, Lordship, and every evidence is before the trial court. So this, Lordship, that is the fit court to be decided, Lordship. And Lordship, now Lordship, at this stage, Lordship, if the court has interfered the imping order, Lordship, then on the basis of the imping order, that charge has been framed and accordingly, these evidences were collected and now it's the verge of completion, Lordship.
No, have you gone through the evidence?
Lordship, this PW, Lordship, that statement recorded, Lordship.
Have you gone through?
Lordship, today only they have received the, yes, Lordship.
Today only.
Lordship has rightly pointed out that Lordship on during the framing of charges, Lordship, the prima facie case material was Lordship evident was there. That's where Lordship charge was framed.
Where is the impugn order? Can I just see once?
Impugn order, my lord. Page number 13. Annexure 1. Operating portion
13 or 30?
1-3.
1-3?
Yes, my lord. Operating portion starts from page number 18.
18. Oh, it's long order.
Long order, man. Those are in the first few pages. My submissions also are there, and the submissions of the learned PP of the tribal court.
Okay.
Page number 18, my lord, the second paragraph,
Hmm.
in the premises aforesaid, after hearing both the learned counsels and perusing the case records as submitted by the police under section 173 CRPC, this court is of firm opinion that the accused person did abet the victim to commit suicide by causing her mental harassment. The accused Narva Pangia, being a married man, was keeping illicit relationship with the co-accused Yagam Jamo, Hatung Jamo, that is the petitioner herein, and the co-accused having knowledge of the accused Narva Pangia being married, kept the illicit relation, resulting in death of victim by committing suicide due to mental torture. This is the only incriminating part, mental torture. That is why I made a co-accused. So, my lord, I placed the many judgments day before yesterday and all, that how mental torture can be attributed to abatement of suicide and all. It depends from individual to individual, the personality of the individual, endurance and stamina, whether the victim was of a weak and fragile mind. All this judgment I place, my lord, in the. So, my lord has observed that yes, the trial has almost into the conclusion part. However, my lord, I may pray that whether there is any chance of conviction.
That we have to go through.
And then, my
Go
lord,
through
I
the
will pray that my lord may either dispose or dismiss this petition, but my lord, I will not withdraw, my lord. There must be a reason order, my lord, for my satisfaction.
Yes,
my
yes,
lord. Yes.
No, nobody can compel you also.
No, my lord, it's a highly observant for patient.
You are determined.
My lord, I need a reason because I have when invoked 397-401 of CRPC for
Either
my humble understanding is, my lord, any state I can invoke this provision.
Allow or dismiss. That's the, of course, the
My lord.
culminating.
My lord.
But then, of course,
Although
nobody
the
would-
trial is at the final stages, my lord. However, my lord.
like a stubborn boy.
Yes. And I did not press for any interim order, my lord, not to disturb the. Yes, otherwise, if this petition is for the sake of, if it was dismissed at this
because
stage,
there is other,
again they will recall the witness.
there is also other witnesses. That is
Yes, my lord.
other accused person, I mean.
Yeah.
So that is
The other accused person, the husband is
And
not contesting. He has not contested even during the framing of charge, consideration of charges. I am the only one who's contesting.
Okay, anything to submit?
My lord, my friend, he has come with, in under section 377, my lord, 397, my lord. My lord, I would like to place some judgment, my lord, where this 397 can be entertained. And how, my lord? My lord may come. Relevant page is
Name of the judge.
9. Well, that also Rakesh Kumar Pandey and another versus State of UP and another. Page
Para?
page 9, my lord.
Para?
Sorry, my lord. Page 8, para 27, my lord. It's a long judgment, but I would like to.
Para 27?
Yes, my lord. It starts from here, my lord. It covers almost everything, my lord, here.
Maintainability.
Yes, not maintainability, but page 8, para 27, my lord.
Page 8?
Yes, my lord.
Okay.
May I, my lord?
Yes.
My lord, in para 8 and 9, the Supreme Court observed, advert to the discussion as to the ambit and scope of the power which the courts, including the High Court, can exercise under Section 397 and Section 482 of the Court. Section 397 of the Court vests the Court with the power to call for and examine the records records of an inferior court for the purposes of satisfying itself as to the legality and regularity of any proceedings or order made in the case. In a case, the object of the provision is to set right patent, my lord, the defect or an error, jurisdiction or law. There has to be a well-founded error, and it may not be appropriate for the court to scrutinize the order, which upon the face of it as a token of careful consideration and appears to be in accordance with law. In one look into various judgments of this court, it emerges that revisional jurisdiction can be invoked where the decision under the challenge are grossly erroneous, my lord. There is no compliance with the provision of law. The finding recorded is based on no evidence or the material evidence is ignored or judicial discretion is exercised arbitrarily or perversely, my lord. So, my lord, in this case, my lord, the court below has given chance to the accused also, my lord, for submission, and there was no gross erroneous or arbitrary, my lord. Now comes to the paragraph page 9. Another well accepted norms is that the revisional jurisdiction of the High Court is very limited one and cannot be exercised in a routine manner. One of the inbuilt restriction is that it should not be against an interim or interlocutory order. The court has to keep in mind that the exercise of revisional jurisdiction itself should not lead to injustice expressly, where the court is dealing with the question to whether the charge has been framed properly and in accordance with law in the given case. It may be reluctant to interfere in exercise of its revisional jurisdiction unless the case substantially falls within the categories as aforesaid. Even framing of charge is much advanced stage in the proceeding under Code of Criminal Procedure. My lord, para 28 is also important, my lord. In fact, my lord, para 28 to
What it says?
30 it covers almost everything. Same is repeated, my lord. 28, my lord. The Supreme Court, therefore,
Okay, if it is a repetition,
not repetition. There is, my lord, 28, my lord.
Hmm?
28.
You said it is repetition.
Sorry, 29, my lord. Para 28 also it covers same. 29, my lord.
It's also same.
No, my lord. Here it's how it the presumption is not a presumption. My lord, 29. In para 10, the Supreme Court observed that if jurisdiction under section 482 of the code in relation to causing of an FIR is circumscribed by person as mentioned in State of Haryana versus Bhajanlal, the revisional jurisdiction, particularly while dealing with framing of charges, has to be even more limited, my lord. Framing of charges is an exercise of jurisdiction by the trial court in terms of section 228 of the court unless the accused is discharged under section 227 of the court. Under both these provisions, the court is required to consider the record of the case and documents submitted there with and after hearing the parties either discharge the accused or when it appears to the court and in its opinion, there is a ground for presuming that the accused has committed an offense itself frame the charge. Once the facts and ingredients of the sections exist, then the court would be in right presuming that there is a ground to proceed against the accused and frame the charge accordingly. This presumption, my lord, this line is important, my lord. This presumption is not a presumption of law as such. The satisfaction of the court in relation to the existence of constituency
So the satisfaction of the court is important
yes, my lord.
for framing charge.
Yes, and my lord, constituents of an offense and the facts leading to that offense is sine qua non or for the exercise of such jurisdiction. It may, my lord, here, my lord, it may even be weaker than a prima facie case. There is a fine distinction between the language of section 227 and 228 of the code. Section 227 is expression of definite opinion and judgment of the court, whereas section 228 is tentative. That is to say that at the stage of framing of charge, the court should form an opinion that the accused is certainly guilty of committing an offense. Offense is an approach which is impermissible in terms of section 228 of the court. It may be noticed that the revisional jurisdiction exercised by High Court is in a way final and no intercourt remedy is available in such cases. Of course, it may be subject to the jurisdiction of this court under Article 136 of the Constitution of India. Normally, revisional jurisdiction should be exercised on a question of law, my lord. It should be exercised on a question of law. However, when factual appreciation is involved, then it must find a place in class of cases resulting in a perverse finding. Basically, the power is required to be exercised so that justice is done and there is no abuse of power of the court. Merely an apprehension or suspicion of the same would not be sufficient ground for the interference in such cases, my lord. My lord, 30 is also very important, my lord.
All the same?
Almost same, but there are some other points there.
But it's too long. Will not allow you to read all this.
Yes, my lord, but I would like my lord to come.
What more?
31 also same, my lord, almost. And my lord, since he has come with the merit, my lord, he has put an argument in merit, my lord.
So according to you, it should be decided on merit. Allow the trial.
No, my lord, it should not be because it cannot be interfered, my lord.
No, that is what I'm saying. It should be allowed to, the trial court should be allowed to decide
Yes, my lord.
on merit.
Yes, my lord.
Okay.
Because it's yeah, the trial court, because my lord, it says that if there is an erroneous, my lord, and if there is no evidence or nothing against against the accused, then the court can interfere. But they had been given chances, my lord, to put an argument. FIR was there, the name of the accused was there, and this is at this stage, my lord, where this is an initial stage where the framing of charges doesn't mean that the person is accused or he will be sorry, the person will be convicted, my lord.
That is true.
Yes, my lord. So
Anyway,
I would also like to place one judgment, though it's on its this is abatement, though I'm not doing it, my lord. Abatement of suicide, my lord.
What is this?
Chitresh Kumar's Chopra versus State Government of NCT of Delhi, my lord.
This is
My lord,
regarding?
this is abatement, my lord. Framing of charges also. My lord, here also I would not like to take much time, but I would like to
Para?
point important para, my lord, is 16, 25, 26, 27, my lord. And now, my lord,
You read the most important paragraph, not all.
my lord, para 16, my lord. Speaking of the three-judge bench in Ramesh Kumar case, RC Lohit J said that instigation is to God, urge, forward, provoke, incite, or encourage to do an act to satisfy the requirement of instigation, though it is not necessary that actual word must be used to that effect, or what constitutes instigation must be necessary and specifically be suggestive of the consequence. Yet a reasonable certainty to
This is,
incite.
okay, but then here I think the case is a little bit different in the sense that there was no word. They have never, I think, confront with each other. Only the allegation against the husband is that husband is involved, and because of the husband involved, and then she in the suicide note says that I cannot tolerate since you are engaged, involved with somebody without naming, no name, nothing.
My lord, may I?
So there is no question of actually.
If my lord may come to the letter, my lord.
By way of a exchange of word or expression of word.
My lord, in that case, I would like to ask my lord to come, pray my lord to come in page 39, my lord, statement of the accused of the main petition. Of the
Petition?
Yes, my lord.
Page
39.
39.
Yes. It's very clearly, it's she herself stated that she had met with the girl. Here, my lord. May I, my lord?
This is the accused.
Yes, my lord.
Okay.
Accused, my lord.
Accused petitioner.
Yes, my lord. So I was in a relation, she's herself accepting, my lord. I was in a relation with Narba Pangia since November 17. I came to know about his marriage in the month of December 17. She came to know already. When I went to SEPA with him for election hearing, we stayed at his auntie's home at type 1 Colony Sepa. At that time, I came to know that he was a married man. She came to know, my lord, he was a married man. I was very upset with him and wanted to go back to Itanagar, but he convinced me a lot, saying that he liked to get me. He also asked me to come with him at Geneva to attend hearing in place of his wife, as she was sick at that time and was not able to attend hearing. I thought to help him for the last time, as he was requesting a lot. After completion of hearing, I came back to Itanagar after 5 days. After this, our relation was not going good. We always fought, and at this tried to avoid him, but he always came back to me and used to say that he will hurt himself if I ignored. After some days, Lakshmi, my lord, the deceased, called me telephonically and told me that she is Lakshmi and Nirva's wife. I told her that I was.
My lord, this is important. I told her.
Yes, my lord. I told her I told her that I was unaware of his marital status, and no onwards I will not keep any relationship with him. But Narba kept my lord, she is not a minor girl that a person will keep forcing, and without that she'll just continue the relationship. Even after this, she continued, my lord. Then in the month of February, Lakshmi along with her 2 cousins and other person came to house. All of them were very nice to me and requested me to stop relationship with Nirva. I always tried, my lord, to avoid Narva, but after 2 days called me again. I was very angry with him, but somehow he always convinced me, my lord, here. He always convinced me how hard I tried to avoid.
Yes, it is all with the husband, boy.
Yes.
Yes, my lord, but my lord, she came, my lord may see here, my lord.
Now, if there is any other word to flee, run away from this boy who forced her again and again.
My lord may see, my lord. The wife came, my lord. She didn't come once. She requested him once or twice or thrice. Even after knowing, first of all, she knew he was married. Wife was not, at that time, wife didn't know. Second time, wife knew, she came and she requested. Now, at this stage, my lord, statement of the accused, how much can we believe that a person has forced? Can someone force someone to be in relationship when the other person is not interested?
This accused was also serving somewhere nearby.
My lord.
Accused was also serving nearby somewhere along with the husband of the deceased.
Serving.
Working.
No, accused is not working. She's unemployed. My
Now,
lord,
my lord,
even if
on
we
many
take this, sorry, continue.
My lord may see, on many occasions, the wife has requested. Now she has given the submission that the husband forced her. But still, because of this relationship, there was a mental trauma, my lord.
But then we need to know the abatement. Okay, anything else?
Yes, my lord. My lord may also come to the letter where
Suicide note?
suicide note, my lord. Where, my lord, I would like to bring one just simple sentence, my lord. Now there was a no name since my
No name.
no name was mentioned. But my lord, after this statement and all, we knew, the husband knew, and hence he also confessed that he was in relationship. The word, my lord. 1, 2, 3.
No, the
Third para, my lord.
27.
27, my lord, type copy.
Hmm.
All I asked from you was your attention and care. I know I have lost it for someone else. Here, my lord, this line, my lord, someone else. Though
Someone else, no
yes,
name.
though the name was not mentioned, my lord, but the husband knew whom she was indicating. We have to see that also, my lord. The statement of the accused, the statement of both the accused, in fact, the family members, everyone knew everyone.
Hey,
knew
this is only expression.
Yes, my
to
lord,
the-
it's an
to the
expression, my lord.
husband,
Agree. Husband, my lord.
Not
But
making any allegation against her.
no, my lord.
The accused.
Yes, my lord. But my lord, may I, my lord, the victim, the lady committed suicide. She committed because of mental trauma, and the trauma was the reason was relationship of a husband. And
But that is why I'm
husband,
saying, that is why I'm saying, we need to know the meaning, the content of the abatement.
yes, my lord. And for that, my lord, I given the judgment, my lord,
Mhm.
where it's clearly written that you don't have to directly, if the mental trauma is also there, may also cause suicide, my lord. It's there, my lord.
It's indirect. Her cause is indirect.
Yes, my lord.
The direct cause, if there is any, probably is the husband. So take the indirect.
Lordship, the direct evidence, Lordship, where this message is recording and the witnesses, Lordship. In the, here, Lordship, the witnesses, the Lordship, this,
Nowhere says that it's because of direct contact, because of those, no?
Lordship.
Because of the abatement, because he is compelled, no?
Lordship,
Not said.
Yes, Lord, the witnesses, Lordship, is her, this victim's sister, Lordship, and the other witnesses, they have named this accused name, Lordship.
Hmm.
Lordship, and moreover, Lordship, the recent Lordship, this
updated
Lordship status has called for Lordship. Here, Lordship, PW Lordship, one PW has stated that there are some messages, some documents that they have already Lordship, they submitted Lordship. So material is there, Lordship. So then Lordship, court has to see whether Lordship, he will be convicted or not. That will the Lordship, the thorough Lordship trial should be proceeded. Because everything in the before court now, Lordship.
Even after knowing, my lord, the girl, the accused has gone in Guwahati, my lord.
Hmm?
Even after knowing these things, my lord, that he was married, and after the deceased has requested the accused for not meeting his wife and not keep a relationship. Even after that, she went to Guwahati with his husband, with her husband.
May I please, my lord? My lord, in all this submission, whether there has been any form of instigation, then I don't have a case at all, my lord. It's
That is
all
why I'm
just
asking.
expressions only. And this abatement definition, we have to see from the earlier code 107 IPC or the section 45 of the Bharatiya Nyaya Sanhita, my lord. Only under this premises, we have to decide whether there was any form of instigation to come to the ingredients under 306 IPC, that abatement of suicide case, madam.
Okay, anything else? Heard, Mr. Jamo, Mr. Jamo, Land Council for the petitioner. Also heard Ms. El Hage, Learned Edison PP for the state respondent, and Ms. Ninti Jera, and legal aid counsel for the private respondent number 2, victim, respondent number 2, staff. Hearing concluded, judgment reserved.
Yes.
Deeply obliged, madam, deeply obliged.
Item number 16.
Just a minute. Hmm? Yeah, I heard it. You're okay. Okay. See you. Yes. Yes.
May I please, Your Lordship? Your Lordship, on the last occasion, Learned additional PP was directed to obtain the fresh present status of the case.
What is the present status? This is regular bail.
Yes, Your Lordship.
What is
Your
the
Lordship,
allegation? What is the allegation?
Allegation, Your Lordship, offense under section 117 clause 3, that is voluntary causing grievous hurt.
FIR rate is 12.
Page 12,
Lordship, page number 12, FIR.
Uncharged.
May I read the FIR, Your Lordship?
Yes.
Your Lordship, with due respect and humble submission, I would like to state that I, Azuba Captain, wife of Hassan Ali, that is, Hassan Ali is the victim, currently residing at Naharlagan G Extension, would like to complain against Bonam Ali on attempt to murder on my husband, who is currently at Trims in a very serious condition. As one of my neighbors named Hasina Begum saw the incident. Incident took place at Lekki village near beer factory yesterday at around 11 p.m. As per eyewitness, she saw that they both were counting some money, and in that moment they both argue each other. And as the eyewitness said, she saw Bonamali punch him and throw him at the concrete wall and hit him multiple times with a steel rod on his head. As per this allegation, Your Lordship,
What happened? Charge it? Filed?
Yes, Lordship.
Okay. Now, what is
Search it as page number, Lordship, 7 and
in it? TCR?
oh yeah, in TCR, Lordship. Operating portion is at page number 9, Lordship. Since there is material against the Lordship, these accused and Lordship, due to his assault, Lordship, the victim is in a vegetative state, Lordship.
Now?
Lordship. And that's why his statement was also not recorded, Lordship. Is it the Lordship?
Now also?
Yes, Lordship. In the FIR, or in the search sheet, Lordship, it was reflected, Lordship. Page number 9, Lordship. Operating portion is page number 9, Lordship.
When the charge sheet was filed, this charge sheet?
Lordship.
charge sheet was filed on 19 February 2025. Yeah, 26, Your Lordship.
Okay. 1912.
Yes, Your Lordship. And accused was arrested on 22 November 2025. Accused is behind the bar for 200 and
Charge sheet immediately filed, I think, on December. But then as the victim could not be examined,
Yes, Lordship.
so the IO also kept open for filing supplementary charge sheets.
Lordship.
Okay. Hmm.
And while
Where have you seen the statement of the eyewitness?
yes,
Hasina?
yes, Lordship.
Where is that?
Oh, I didn't mark the Lordship. I didn't mark the Lordship or the statement, Lordship. But it is in the search sheet, Lordship. In fact, the intention was to kill the Lordship, to
For
murder.
money.
Yes.
But initially, probably there was no intention, but in
yes,
subsequent.
Yes.
Your Lordship. FIR itself says that Your Lordship, the Your Lordship, FIR itself says that your lordship, out of altercation over a monetary dispute, there is a dispute between the two. They both were fighting each other, your lordship. There is no intentions. And your lordship,
Just a minute, sir. This, probably this Hasina Begum is the eyewitness.
Yes, lordship. And she happened to be the lordship, the girlfriend of lordship, this accused.
Oh. Then she's interested witness.
But
What is the name of the accused?
Name of
Bonamali.
Bonamali lordship.
Hmm?
Bonamali lordship.
Okay.
Bonamali.
Bono.
Elias Banamali Patir. Bonamali Elias Banamali Patir.
I saw beating with my eyes. Hit with the rod
Yes, sir.
and a wooden stick. Who is this Johra? He is the wife. So you filed bail application before the trial court earlier?
Yes.
That was rejected.
Yes.
When last it was rejected?
It was rejected on your lordship. I have annexed number 5/26. It was rejected on 7/4/2026. Stating the ground that there is a prima facie.
Okay, only one bail application?
Yes, your lordship.
Okay.
And
okay.
your lordship, may I be please?
Yes.
Your lordship, accused person is behind the bar for 220.
Maybe. Charge is filed. There is
Yes.
a prima facie case
And
against him.
Since your lordship, the trial is going on at the trial court, your lordship, usually criminal trials take long time to conclude. Therefore,
Yes.
your lordship detaining the accused person for an indefinite period
Yes, okay.
amount to free trial punishment.
Mhm.
And your lordship, under criminal jurisprudence, every accused person is innocent until proven. Therefore, your lordship, continued detention would violate the fundamental rights to personal liberty granted under Article 21 of the Constitution. Your lordship, further, the apex court has laid down the principle that
Whether all the FSL report have been received?
Lordship, last occasion I was perused, but I don't remember lordship. Today, due to the positive time, I didn't go through this year lordship.
What is the status IO says regarding the further investigation?
Since lordship, his statement, victim statement was not recorded, lordship.
Only the statement of the victim
Yes,
remains now.
lordship.
Otherwise, the charge is filed.
Yes,
The
lordship.
court, if fine, can also proceed with.
Yes, lordship.
Your lordship,
Hard, Mr. Mr.
P. Tabing.
Okay, P. Tabin.
Your,
P.
your,
Tabin.
Tabing.
Tabin.
Your lordship,
Learned counsel for the petitioner.
to substantiate my argument, I would like to place.
I have
statement-
heard you. What more you want?
Sorry.
Learned counsel for the petitioner. Also heard Mr. No, another PP for a state. Stop. Huh? Who is the petitioner?
Your lordship,
Wife of- Why?
Mahendra Patir, this is, he is the uncle of accused person.
Okay, the petitioner is stated to be the uncle of the accused,
Paternal uncle.
Banamali Patir, who has been arrested in connection with Nirjali PS case number 9525 under section 1173 of BNS 2023. It's only 117 only,
Yes, your lordship.
the charge sheet,
Yes, your lordship.
only one section mentioned.
Yes, yes.
Okay. Stop. By filing this application under section 483 of Bharatiya Nagrik Suraksha Sanhita, the petitioner is praying for grant of bail to the accused. Grant of regular bail to the accused. Huh?
1173, lordship.
Hmm?
1173, lordship.
1-1?
11 clause 3, lordship.
Okay, okay.
Which is punishment is
Okay,
up to
now,
life.
now it will come earlier in connection with you leave, huh? Only uncle make the relationship, and then here, who has been arrested in connection with usually PS put here, huh? PS case number 9525 under section 117, close within bracket 3 of BNS 2023. Stop, huh? It is submitted that earlier the bail application moved before the Learned Trial Court. The Learned Session Judge, before the Learned Session Judge, UPI has been rejected on 7/4/2026. A bail application moved before the Learned Session Judge for release of the accused have been rejected on 7/4/2026. And this is the subsequent bail seeking release of the accused on the ground that.
Your lordship, para 11.
What is that?
Para 11, 12, 13.
What is that?
That is my ground for bail, your lordship.
The investigation of the case has already been completed. The police has submitted charge sheet. Already submitted charge sheet. And the trial is yet to begin, which might take longer time. And since the accused has been inside the custody since how many days?
223
For about 223
23 days.
days, he cannot be detained for an indefinite period before conviction, which according to the counsel for the counsel for the petitioner would amount to a pre-trial punishment. Stop, huh? Mr. Low Ilan PP produced a case study and I produced the same. Produce a case study and peruse the same. Stop, huh? Par. Well, how many days you said? 200?
223 days.
Okay, having been arrested on 22/11/2025, huh? After that, huh? Hmm. Then produce a have perused the same, huh? Stop. Mr. Loy, before us, submits that the allegation against the accused is very serious in nature. Although the investigation of the case has, although after investigation, the case has been submitted in the charge sheet. However, the statement of the victim could not be recorded as he is still under a vegetative state. And in view of the above, the eye of the case has kept open for filing supplementary charge sheet after recording the statement of the victim. The Lana PP further submits that the record reveals that there is a prima facie there is incriminating material showing the commission of the offense by the accused. Incriminating material available showing the commission of offense by the accused.
And victim was in vegetative state, Lordship.
Yeah, that is already recorded.
Yes.
And under the circumstances, if the accused, and under the circumstances, while objecting the release of the accused on bail, is submits that at this stage, if the accused is released on bail, there is. So your objection, what is the ground for your objection?
Since Lordship, victim statement was not recorded, Lordship, there is possibilities of Lordship.
Okay. There is a possibility of the accused influencing the victim and other witnesses of the case. So the main accused is his girlfriend.
Lordship.
Or sure or not?
Lordship, they are laborers working together.
Yes,
Lordship.
your Lordship.
Girlfriend.
No, Lordship. Both the accused and Lordship, accused and the victim are laborers, Lordship.
Construction labor.
Construction workers, Lordship.
But you see, of course, that is true. Under the circumstances, if the accused is released, there is every possibility that the accused may influence or hamper or tamper with, influence the evidence of the case. Stop. Therefore, he vehemently raised objection to the grant of bail to the accused. Stop. After both the land counsel for the parties and also peruse the record. Stop. The record reveals that the there is a as per the record, there is a incriminating material against the accused for commission of the alleged offense. The eyewitnesses has clearly stated against the accused. And due to the grievous injury caused by the accused, the victim is still under vegetative state. Under the circumstances, it appears that under the circumstances, considering the grievous nature of the offense and also considering that there is a sufficient material against the accused for commission of the alleged offense, this court is not inclined to grant bail to the accused at this stage. Accordingly, this bail application stands rejected. Okay.
Matter number 17.
Lordship, this bail application was filed on 8/6/2026. Lordship. Lordship, that without going into the merit of this case, Lordship, there is a procedural lapse, Lordship.
Your Lordship, the TCR has not been received yet.
Okay.
Since this
let
is
the trial
this
court
is a
record this.
regular bail, that would be necessary, Lordship.
Okay.
Lordship,
What is the offense
Lordship, offense is
under section
NDPS, Lordship.
NDPS?
Yes, Lordship.
Commercial.
21 commercial.
Yes, Lordship.
Okay. How long he has been inside?
Lordship, it's been 3 years and 3 months, Lordship.
3 years.
3 years.
What is the progress of the case?
Yes, Lordship, my submission is, Lordship.
No, what is
what-
the stage of the trial?
The stage of the trial is, Lordship, as per the bail order, because of the co-accused, that there cannot be further. This trial is delayed because of the.
Now, how many prosecution witnesses has been examined by now till that?
Lordship, in fact, in this regard, this record was called.
The record is necessary. Then in that case, Mr. G. Kato, Learned Counsel for the petitioner, staff, Miss Jeannie, Learned additional PP, Mr. The trial court record is still awaited. In view of the above, let this matter be listed after the ensuing summer vacation.
Yes.
The registry shall issue reminder for the trial court record. Okay.
Matter number 20.
Yes. Yes.
Morning, Lordship. I file my power, Lordship. On private respondent, Lordship. Sole private respondent, Lordship. Sole respondent, Lordship.
You are
Lord.
correspondent?
Yes, Lordship. The civil revision petition, Lordships. The execution petitions was filed, Lordship. In the execution petitions, Lordships, civil warrant was issued for the violations of the so-called notice, Lordship, issued by the executing court, Lordship. Lordship, interim order was passed, Lordship, on 24. Lordship may kindly peruse 24 order 24/04/2026, Lordship. May
You are
kindly peruse.
correspondent?
Yes, Lordship.
No, then what happened?
Now, the condition order was passed, Lordship.
Okay, whether he has paid the
No,
money?
not yet, Lordship.
Now then this,
Yes, Lordship. This is condition order.
Lordship, I have intimated my client for payment, but it has been.
not paid. Then this interim goes.
Instruction
Yes, Lordship.
from him also.
Then the interim goes.
Yes, Lordship.
Lordship,
This is, it's a
uh,
conditional order.
Yes, Lordship.
Lordship, let us humbly pray that a short death may be given to whatever the substitute.
Short date would be tomorrow.
After this vacation.
Lordship, may kindly peruse the order, Lordship.
No, I've seen
Lordship.
the order. This is a
Yes.
conditional order.
Yes, Lordship. Conditional
If
order.
he failed to pay the amount, then this order goes.
Yes, Lordship. Kindly vacate this order, Lordship.
I have to vacate it.
Yes, Lordship.
Lordship, it is my humble.
This is
prayer,
more than 2 months, Lordship.
kindly,
It was passed way back in the month of April.
Yes, Lordship. More than 2 months.
till this summer break, Lordship, is my humble prayer.
Till summer break, you will pay.
Yeah. I'll.
If they are ready, so
Yes.
execution petition, how, okay, warrant.
Execution notice, Lordship. Execution notice was issued.
He did not
Notice
appear.
was issued. And on the,
Did not appear before.
yes, did not appear. Then, pass the civil warrant, Lordship.
Yes.
Civil warrant.
It is to be executed.
Yes, Lordship.
Lordship.
No, Lordship, it's not executing, Lordship. This is just so cause notice was issued, Lordship.
Okay.
Notice was issued, and after receiving of the notice, Lordship, the
Can we
judgment
put it-
debtor not appear before the
He or she,
he, Lordship.
he.
He not
Tell him,
appear before
tell
the
him, tell him,
executing court, Lordship.
tell him, don't spend money on me. Pay there.
Yes,
Because no alternate in such cases.
yes, Lordship. This is consensual order, Lordship. Lok Adalat order, Lordship.
That is why I'm saying
In this,
no alternate.
yes. But,
And see, probably it was some crore, came down to 90. So he should feel happy.
he will be paying, but we are only challenging the order passed by the learned civil court for issuing a.
Oh, why you allow the civil court to pass such order if you are ready?
Yes, because
Pay.
the other party has not shown proof that whether the notice was delivered to the petitioner or not, like the record, whether he has actually received the notice or not. My client was not, he had not
See,
received.
see, the execution petition already filed.
Yes, Your Honor.
Now you have no alternate.
Yes, Lord.
Even if you go to jail also, you are bound to pay.
Yes, Lord. But
That will not, see, even if you go jail also, but this payment you have to, you have to make. So there, that is why there is no alternate. So you pay. So what we can do is that, since he is ready, let us give him chance, this, vacation
Modifying this
period,
order, Lordship.
vacation period.
Yes, Lordship.
But then, we'll fix immediately after the vacation. And then during this period, if they fail, we'll vacate. Now also we can vacate,
Yes, Lord.
but then what is the ultimate? Even if he go to jail, he will not be able to manage the money even
Yes,
if
Lordship.
he go to jail. That is why, so this period, 2 weeks time will give.
Yes, Lordship.
Then thereafter immediately will get listed and within this period, and you are bound, no option at all.
Yes, Lordship.
Absolutely no option, but to deposit, but to submit. So, you clearly instruct your client to pay during this period. Otherwise, you will not be able to bargain. Tell.
That order may be suffice, Lordship.
Mr.
A. Gamre.
Land Council for the petitioner. The hard Mr. Land Council for the petitioner, who submits that? So you are, could, able to contact your client?
Yes, Lordship.
Okay, who prays for who submits that although he has informed his client, but the reply is still awaited. Therefore, we praise that one more chance may be granted to him to obtain proper instruction. He also undertake to inform his client that the order dated 24/4/2026 is a conditional order, and unless the amount, unless the decretal amount is paid, the interim order passed will be vacated by the next state staff. Mr.
Mr. Jeevam Lordship.
He?
Jeevam Lordship.
Sorry, G. Bam. Bam, your name is not there?
Lordship, today morning, Lordship, I filed my forward, Lordship.
Okay. Mr. G. Bam, Learning Council appearing on behalf of
Sole
the
respondent.
respondent. Sole respondent
Yes, Lordship.
has objection. However, considering that, considering the prayer of the council appearing on behalf of the petitioner, that the petitioner would be depositing the decretal, would be paying the decretal amount within these two, within the period of 2 weeks. He submits that the, he further submits that the petitioner be ensure, petitioner be ensure that, ensure that the, that, that the order is properly complied with. The undertaking given is duly complied with. Stop. Stop. In view of the above, and as prayed for, list this matter again on immediately after vacation would be
That may be given.
21 lodge,
20,
21 or lodge?
1.
Lodge.
21 is DB day.
DB Lordship.
DB day, but 20 is election petition, 22 also election petition.
Okay. How many
23rd
fixed matters
also
are there? Don't keep too many fixed matters.
24 lodge, the
Hmm?
Friday, 24.
No, no, 24 is last date.
Yes, sir.
Don't keep.
Lodge.
So 21 is okay. 21.
Much obliged.
Item number 21 to 23.
Yes. Mr. Tudu.
Yes, Mayor, my lord.
What is this IA for?
My lord, IA is for my lord, may kindly come to annexure 1, my lord. Page number 11, my lord, operative portion, my lord.
Now, what is this IA for?
My lord, IA
Application
is for my lord, while granting AV, my lord.
Huh?
My lord, this court, Honorable Court, my lord, while granting AV, directed the accused person to execute the bail bond of rupees 2 lakhs, my lord.
Okay, then
lakhs.
what happened?
So, my lord, my contention is that, my lord, when we went to the, my lord, police station, my lord, for recording, for a statement, my lord, the police is insisting us to deposit the amount before the court, my lord. So, my lord, my contention, my law is very clear in this regard, my lord. Bail bond amount is not bound to be deposited in the court, my lord. This is the
Where is there any written communication?
my lord, there is no such written communication.
No, then in that case, what do we do?
My lord, we went to the, my lord, we went to the on 29 and 30 of this month, the last month, my lord. We went to the, my lord, police station, my lord. My lord, are you and concerned?
Instruct the police is not to be deposited cash.
Yes, ma'am.
It's not the case which is to be deposited. The bail bond amount, any document, anything. They keep instruct. There is no written document. We cannot give direction.
My lord, in such cases, my lord, they cannot give us written document also, my lord. My lord, in such a situation, the officer in charge also cannot, is not giving us any document that saying that
we are bound to accept the case. They are only saying that you have
This
to
AB
deposit.
or regular bail?
Madam, AB, madam, AB.
AB.
Yes, madam.
Oh, otherwise you appeared.
Yes, I appeared.
Have the record?
I appeared, my lord, my
Whether your statement recorded?
not recorded. That is why, my lord, when I appeared, there for education.
You have the record of your appearance?
Madam, no such records, madam.
No. Whenever you go to the police, why don't you keep your attendance sheet? One, please acknowledge my attendance, appearance. Get it signed. Otherwise, how do we know that you appeared?
My lord, that is.
How will we know?
My lord, are you insisting at before execution of this bail, my lord, execution of this bail? They are insisting us to deposit the amount to the concerned jurisdiction magistrate court, my lord. So that is why, my lord, the foreign case is not yet
This
started.
AB is to be before the
Concerned magistrate, Your Lordship.
is before AB also concerned magistrate.
Yes, Your Lord.
What the order say? Arresting officer.
There is no such, nothing is mentioned here.
Your Lordship will come to paragraph 11 of page number 11, Your Lordship.
Arresting authority says so.
Yes, madam.
It is arresting authority only.
But they are insisting us to deposit this particular 2 lakhs bail bond amount before the jurisdictional magistrate court first, madam. Then they will do the other necessary policies.
Your Lordship, I'll just clarify here, Your Lordship. The arresting authority, Your Lordship, once this execution is being directed from the court, Your Lordship, even in the police station, the account number of the CGM is being given, Your Lordship. The arresting authority will take this money and then deposit it to the concerned magistrate court. All the bail bond amount goes to the magistrate's account, Your Lordship. It does not stay with the investigation officer.
But here, my lord, my case is, my lord, we are not bound to deposit this particular amount before the magistrate court, my lord. We are not bound. It is only bail bond amount, my lord.
If I may, Your Lordship, my colleague's main intent, basically he's submitting that the the bail bond amount of 2 lakhs is not to be deposited in the form of money.
Yes, madam.
Either to the magistrate or the arresting authority.
Yes,
and since the surety, there is a
surety
direction with surety, Your Lordship, of 2 surety. So the surety part covers the 2 lakhs part, Your Lordship.
Surety part covered.
2 lakhs part. There is no necessity to deposit the 2 lakhs amount, Your Lordship. His contention is that.
So, my lord, law is very clear. On
What
this.
are you producing for the bail bond and for the surety?
For surety, my lord, if the arresting authority asks us to give any kind of property, we are ready, my lord.
Surety, any document will
Yes,
do.
we are
Okay.
ready.
And for bail bond?
But bail bond amount, this particular amount, we are not supposed to deposit it in the court or before the arrest.
What the law says?
My law says, my lord. So, my lord, that is why, my lord.
But then if it is if they accept, you are from outside, if they are insisting
My lord, there is,
and not satisfied with the property or whatever document you submit or deposit, then in that case,
my lord, there is no such provision in the, my lord, BNSS. For
Okay.
insisting on the accused person to deposit the.
what document did you produce?
My lord, they are not giving us an option, my lord. They insisting us to deposit, my lord, particular case amount, my lord. 2 lakhs case amount for the concerned magistrate court, my lord.
What you propose to deposit?
My lord, we on our part, we are ready to produce any value, which is.
What?
My lord, that it depends, my lord, if on the basis of the, my lord,
What bail bond amount you offered?
any kind of property or document.
Then the police was not satisfied with your offer.
My lord, that was not the case, my lord. The only there on this point that this bail bond amount has to be deposited before the magistrate court, my lord. That is there, my lord. On past instance, they're only insisting on this point, my lord. They're not giving us any kind of, that you produce such kind of document. And nothing is there, my lord. So, my lord, law,
So you produced whether he reported he appeared before the police or not. And then you appear before the police and get the documents of your acknowledgement of your appearance
And my
before the
lord-
police, then we'll pass
my lord,
necessary
I'm
order.
ready to appear, man. I'm ready to appear, but my lord may kindly, clarify.
There is a direction to appear.
Yes,
So if you appear
yes,
unceremoniously without record, in such cases, it happens. So, but then that is why you should go ready with a copy of the appearance,
yes, my lord,
attendance,
we went quite.
and get acknowledgement.
My lord, if, direct the concern OC, my lord, not to insist on
No.
deposition of case, my
That,
lord. That is the
that,
case.
that cannot be done. I'll-
No,
I'll-
not
I'll-
at the moment,
I'll-
not at the moment.
Yes.
Mm.
And more particularly, your lordship, if
Mm.
as
Okay, Mr.
My lord.
Mr.
My lord,
Planning Council for the applicant.
my lord, just, my lord, give me, just,
Mm.
my lord, I will just want to clarify some law.
Okay,
regarding
Miss,
this.
Miss, J.T. Ginny, Planet Additional PP, prays for some time to obtain instruction. In this
Lordship,
regard, the prayer is allowed. List is met on.
My lord, this,
You know-
my lord, this actually, my lord, this matter is fixed next on this
27th or 7, your lordship.
And
27th,
As,
okay.
as far as my instruction, I'll just clarify, your lordship, because I would suggest, just for the sake of suggestion, your lordship, if suppose he, for his sake of submission, that 2 lakhs is not to be deposit, and it will be, it
That
will
is
be,
refundable, if any, even if you deposit also, that is refundable also.
and
my lord,
also
my
the
lord.
forfeit, there is a provision for forfeiting if he does not comply with. The other thing is, your lordship, 490 of BNSS clearly state that the deposit instead of recognition. So if he does not give something to recognize that you recover this amount.
That is why I was asking, what did you
Yes.
offer?
My lord.
If he has to deposit something as a surety of 2 lakhs.
You take whatever you are offering. This is, I'm appearing, kindly acknowledge my presence. And this is the bail bond offering. You acknowledge,
My
get
lord,
it
that's
acknowledged,
what-
we'll
that's what
examine.
my lord understand, my
That
lord.
is not there even in the statement of this, statement in the
My
IA.
lord, just give me a few minutes, madam. I just try to convince, madam.
See, I remember this accused person, there is a problem.
But
They need to, they need.
But
to
my
deposit.
lord,
This
when-
is- I think this involved with the
when
money
Madam
only.
It is submitted, this case has to be deposit, madam. That is, when I have to execute the bail bond, madam. When I have to execute the bail bond, this case amount has not to be deposited, madam. That is the case, madam. Madam, my parents, kindly parents 490 BNSS. 490 BNS. Madam, law clearly says that-
BNSS.
Yes, madam, law clearly says that when you are executing a bail bond, you don't have to deposit the case money, my lord. That is my case, my lord. 490, my lord, 490 BNS.
490.
490, my lord, 490. BNSS.
Yes.
Madam, may I read, my lord? Deposit instead of recognition, my lord. Recognition here means, madam, bail bond, madam. When any person is required by any court or officer to execute a bond or bail bond, such court or officer may, except in the case of a bond for good behavior, that is different case, madam, permit him to deposit sum of money or government promissory note to such amount as the court or the officer may fix in lieu of executing such bond, my lord. Here I am executing a bond, my lord. This is the case, my lord. Here I am executing bail bond, my lord. This is like
Okay.
this
A sum of money.
This yes.
See, he is insisting a sum of money.
Yes, madam. But my order.
And what do you want?
But my
Or government promissory notes.
my lord has.
That is why I am asking you, what did you offer?
My
Which
lord,
the IO refused.
my lord, as per the direction of this honorable court.
Promissory notes to such amount. Okay, to such amount.
My lord.
As the court or officer may fix in lieu of the executing such bond.
That is why, my lord.
Say, we did not fix. So the amount or the promissory notes, you have to deposit.
My lord, that is why, my lord. In the bail condition, my lord, I was directed to execute bail bond amount of 2 lakhs, my lord. I have
Yes.
have to execute.
What did you offer, Mr. Kurdo?
My lord, I am there.
I'm sorry.
My lord, I would offer, my lord, any documents if they require, but not to deposit the particular case amount, my lord.
Oh my
That
God.
is, my lord.
Unless you offer something, the the police is insisting you to deposit. I'm asking you to just offer in writing. You are saying that police is playing. They are not accepting that you appeared, that also not recorded, okay? You now just go with the written document saying that, please, I'm appearing before you today at today at 11 a.m., whatever, okay? Kindly acknowledge my appearance before you as per the direction of the court. And I'm offering this bail bond instead of this, okay? Kindly accept this.
Maybe a document of the land.
There-
Maybe
anything as per the law.
My lord.
Okay. Okay, obtain
I'll
instruction.
take
Okay.
it.
Matter number 24.
Yes. Trial court record not yet received.
Your Lordship,
Received.
I have just been informed that.
What is this about? Criminal petition?
Yes, this was, they had come before this court when the case was reserved for judgment, Your Lordship. And I have been informed that the accused has been convicted by the judgment dated 30/6/2026, and on 13/7/2026, the case is fixed for hearing on sentence.
Okay.
So this becomes instructors, Your Lordship.
Instructor. Okay, so now it's sentenced,
Yes.
already convicted.
Yes.
Okay. Hard
He might
discharge?
otherwise.
Tirar,
Planning Council for,
Tirar,
T?
Rar, RR.
O R A R.
RR.
Okay.
Lordship, kindly give liberty to withdraw the case as
Okay.
case is already convicted.
Okay. Mr. T. Rap, Planning Council for the petitioner submits that his case has become infructuous, therefore he wants to withdraw this criminal petition as on becoming infructuous. So the learned additional PP, Mr. P. Ginu has no objection. Raised no objection. Starting. Accordingly, the prayer is allowed. This criminal petition stands dismissed on becoming infructuous. It will say, we're not withdrawn. Withdraw, say, okay, oh, age withdrawn. Okay.
Deeply.
Okay.
Matter number 27, unlisted motion matter.
Oh, it will be difficult. 27, difficult. Kumar, bola. So it will be difficult.
So this share case, Lordship.
Huh?
This
Maybe,
share case,
yeah,
complaint case, Lordship. Complaint case. So we are only performer party, Lordship.
On 16/7, there is a matter fixed for complainant witness.
So we'll take break of 5 minutes. Yes, what is your case?
Your Lordship, this is
Huh?
a complaint case. Your Lordship,
What?
complaint case under 143 of the NI, 138 of the NI. 133, 2026. The matter was fixed for explanation of offense. So, and simultaneously on the same day, the learned judicial magistrate first class has awarded interim compensation of 20% of the check amount against the accused person and directed him to pay the interim compensation amount within a month. Again, the matter was listed out on 22/06/2026, whereby in view of the non-payment of the interim amount, the learned judicial magistrate passed an order directing that the petitioner shall pay the interim amount, imposing a condition that if the petitioner failed to pay the interim compensation amount, his right to cross-examine, he shall not avail the right to cross-examine the witnesses.
Hmm?
So the order, while passing the
When next date is fixed, you said?
16/7/2026. Your Lordship, while passing the interim order dated
For what?
for complainant witnesses. While passing the interim order, the learned judicial magistrate has exceed the jurisdiction and the order, the interim order was passed beyond the scope of section 143A of the NIA. Section 143A of
Just a minute, let us see, the order.
Annexure 1, page number 13, page number.
Particulars of the offense. Use the law, explain to the which the previous not please and plan to be correct. However, in that case, the government is liable to only to the extent amount of the case. Important compensations.
One 43 of the NI Act, the court has power to pass an interim compensation amount of not exceeding 20% of the check amount.
So here in this case, how much?
20% has been passed.
20%?
20%.
What is wrong in it then?
No, we have not challenging the order of interim compensation amount. The order which has been challenged is dated 22/6/2024. In the last paragraph, page number 16.
Okay, within the month, did you pay?
No, Your Lordship. till
Then-
we have not, no, Your Lordship, order dated 22/6/2000. May I read?
What is that?
Operating process,
Mhm.
page number 16. Considering the submission from both sides, this court is of the opinion that there is no more opportunity shall be granted to the accused to seek adjournment and that non-payment of the interim compensation pending the disposal of
Where are you reading?
page number 16.
16.
16. Of
Just a
order
minute,
dated
just a minute, just a minute. Accused unable to appear court also.
application was filed under section.
You have to pay the interim compensation. For accused was repeatedly filed dispense application to adjourn the case and delay the court proceedings. Act of the accused is violating the right of speedy trial of the complaint enshrined under so and so. Considering the submission from both sides, this court is of the opinion that no more opportunity shall be granted to the accused to seek adjournment and that non-payment of the interim compensation pending the disposal of this case has caused huge loss to the company. Hence, this court is of the opinion that the right of the accused to cross-examine the complainant witnesses will be subject to the payment of the interim. Yes, what is wrong in it?
Your Lordship, under the scheme of NIA, the magistrate has no.
Forget it, forget it. There is a conditional order. You have to pay first. How do we proceed? You have to pay.
For the payment, to ensure the payment of interim amount, the court cannot put condition precedent.
Why?
Your Lordship, there
Why
is
not?
a
Why not?
express
Who? What
provision.
prevent the court?
Your Lordship, there is an express provision.
How do it
The-
progress? And you are not appearing also.
No, Your Lordship, because of unavoidable circumstances, they.
Oh, Learned Counsel, see, there is a conditional order. You have to pay within 30 days. And what you want the court to do against you? You put
Your Lordship, there is a, Your Lordship, I have authority from.
what authority?
So,
Now, within 30 days, did you pay?
no, it was.
What step you have taken? Did you pray for the extension?
Your Lordship, application under section.
No. What did you do after that? Because there is a, the you were directed to deposit within 30 days.
Your Lordship, if I default to make the payment, it can be, it can
What?
recover as a fine. Under section 421 of the CRPC.
You want,
It's
you
clear-
want that him to file for recovery again.
No, it can be fine, it can be executed, order can be executed, but the non-payment of the interim amount cannot be resulted into denial of the right to cross-examine.
Now see, the court probably did not find any alternate. That is why court had imposed this conditional order. Or see, the case will proceed on your deposition, meaning you deposit, proceed the trial.
You know, but the way the court has passed the order,
What is wrong in it? What is wrong in it?
kindly, Your Lordship, may come.
See, what is the alternate?
Alternative, Your Lordship, there is an express provision. First, they have to exhaust.
Now the court sees
Yes.
that you are avoiding the trial, you are not appearing, repeatedly seeking adjournment, repeatedly not appearing before the court, and at the same time not depositing. What alternate the court does have?
Cost can be imposed.
Then course, you will not pay the cost
No,
also.
I have paid. On one occasion, the cost was.
See,
imposed.
see, your technique, it appears from the court's order. Court has made a clear observation against you. Under the circumstances, how do you expect this court to pass order?
Your Lordship, kindly, I may be allowed.
What is that? The accused is yet to pay interim compensation as directed so and so. The accused repeatedly filed dispense application to adjourn the case and delay the court proceedings. This act of the accused is violating the right to speedy trial of the complainant enshrined under so and so. This is rather, it is in your favor only. You want the trial to be delayed. The court is delaying only because cooperating with you, isn't it?
Your Lordship, we'll
You wanted this to be delayed.
on
Court has accepted.
next step we will
Hmm.
appear.
What is it?
We-
What
we-
is,
we are
where,
doing our
where is the relevant portion?
Para, para 12.
Yes.
Para 12. After empowering the court to pass an order directing the accused to pay interim compensation under subsection 1 of section 143A, subsection 2 then mandate that such interim compensation should not exceed 20% of the amount of check.
It was 20% only.
Yes, no,
Okay.
we are not challenging
Yes.
the amount. The period within the interim amount compensation must be paid is stipulated under.
Yes, must be paid.
Yes, Your Lordship.
Yes. Did you pay?
No,
You failed. Okay, then.
while subsection 4 deal with the situation where the drawer of the check is acquitted, said subsection 4 contemplate repayment of interim compensation amount along with the stipulate as stipulated. Subsection 5, Your Lordship, this is important. Subsection 5 of the said section 143 then stated interim compensation payable under this section can be recovered as if it were a fine.
Hmm.
The expression interim compensation is one which is payable under this section and put the stake within the suite. The interim compensation directed to be paid under subsection 1.
They will take. He will, probably they will file
It is the same
application.
situation. Herein also, the trial court has put condition on the right of the accused person to pay the interim compensation. In failure, the right to examine the witness was curtailed. So this judgment has clarified that if there is a provision, that provision has to be exhausted. Because
See, that will exhaust. And probably the complainant will take steps for filing for recovery as a fine.
as a fine,
Wait for that.
for attachment.
We do not know as of now.
Your Lordship, if I fail to pay the compensation, my property can be attached. I
Yes,
can be put
yes.
in-
Let,
Yeah.
let,
But-
let
but my
the
right
occasion
to
comes.
Examine
Hmm.
the witness cannot be curtailed because to
It is not curtailed. Are you ready to pay the
You know,
compensation?
we are making
20%?
endeavor to make the payment.
Are you ready to pay?
You know-
You pay. It's as simple as that. You pay and just let the case proceed.
We are making endeavor to make the payment.
That is why I'm
If
saying,
possible.
the moment you pay, you get this right.
You know, it's fine.
It's only for the time being only. You just pay and then you will be allowed to cross-examine. It's not that you will not be allowed to cross-examine. It's not that. It is only that after payment of this compensation only will proceed.
But the law is very clear.
You want this to proceed, proceed as early as possible, the case to proceed.
No,
It's not a denial. Are you alleging that this is a denial?
no, Your Lordship.
Then what you want?
In-
You are also not appearing the court, and now as if you are appearing, and as if this is a hurdle against you. No.
no, on-
Land Council, I think you have to rethink about it. This order, although it is against you, you think, but it's not against you. Your conduct, as per your conduct only, in order to ensure that you deposit this 20%, I don't know, in the meantime, they will file application for recovery as a fine. Wait for that also.
You know,
That,
if
okay,
it's-
that time has not yet
for
come.
for any reason, if I fail to make the payment on or before 16/7, then I will be not allowed to cross-examine the witnesses. That means technically I have been denied from a,
Where?
if I cannot cross-examine the witness.
You have not been debarred from cross-examining. Today you pay, tomorrow you cross-examine, finish. Is it not the case? You just pay. Where,
Your Lordship, in that case, Your Lordship, express order may be passed. I'll pay,
you'll pay,
I'll pay, but Your Lordship,
within how many days?
we are making endeavor to make the payment.
Oh,
Your
yes,
Lordship,
you-
even
clarify. We'll pass order.
pass-
You just
No,
say,
Your Lordship,
give the
may-
date.
may I-
give the- See, time, repeatedly giving time to you, this is technique. And probably it is truly applicable to you. So then, why should we give time? You just deposit, and the moment you are denied from cross-examining, then you come. The method and maybe method. See, so you are making endeavor.
I'm making in.
Try to understand. You tomorrow, no, on Monday, you deposit. You pray that the case be fixed on Tuesday and then to allow you to cross-examine. If that is not allowed, if you are not allowed to cross-examine, then will immediately pass order, necessary order. It's not a case that you are debarred. Only by observing your conduct in the case, this order probably has been passed. And then it's not that you are debarred or you have been refused. No, you probably have misunderstood that. This is premature. It's not a debarment, not a denial. So when you are denied, you come. This was passed on 3, and then see how many months? 4, 5, 6. More than 3 months passed. You have not yet deposited that compensation 20% also. You deposit the next date and then seek for the time for the next date. Okay. Better withdraw with the liberty. Better withdraw with the liberty. Withdraw with the liberty to come again if you feel aggrieved. Okay. Okay. Mr. Learned Counsel for the petitioner. Sami says he may be allowed to withdraw this criminal petition with liberty to file afresh. If so advised. Okay, the prayer is allowed. This criminal petition is dismissed as withdrawn with liberty as prayed for. Okay.
Right.
Yeah, Lordship. Lordship, this matter may be released after vacation, Lordship. Take
Why?
after vacation.
You have seen it.
Due to the shortage of time, my lord. Otherwise, we would have considered, my lord, with the facts, but since the senior has gone, so.
Okay. Okay. Okay, you are protected by the interim order also.
Yes, Lord.
Hmm. Okay. Ms. Gao, Learned Counsel for the hard Ms. Gao, Learned Counsel for the petitioner, also hard Ms. JNT, General Learned Counsel appearing on behalf of the respondent, staff on the prayer of both the Learned Counsel for the parties. List this matter.
After
Date or
vacation, my
after
lord.
the-
Immediately after vacation, my lord, whichever date is.
Immediately after? You wanted the fixed date?
No, my lord.
Okay, immediately after the ensuing summer vacation. Okay, that is enough.
Lordship into, that into may be continued.
Okay. The interim order passed earlier shall continue till the next date of listing. Okay.
Okay, Lordship.